mention was serial number 11 from the daily was missed.
So, don't mention anymore. Why do you want to mention?
In addition, the stay granted in that case is still today, and that is 5th of August itself. The stay of the execution
Wait
proceedings.
for the other side has appeared.
Other side has not appeared. Last date also, other side did not appear despite the ST service of notice.
And now you are served.
We have served in addition. We have served on the last day 29. Stay was granted till today, and today the case is posted under the heading of final disposal.
Yes, we'll see that. If it is not taken up till the evening, you just let us know.
And
This case from daily is item 10, second April 352 of 2016.
इसमें the amicus has made a request for adjournment. Otherwise, also no respondent is not appearing.
Yes.
कितने दिन का adjournment का request है? आज भर के लिए. तो कल करा करते. आज भर के लिए. कहाँ है request? Any date in the next week. Council Bhattapinat is present.
The amicus appointed is
Next week.
next week.
He has made a prayer for next week.
Yeah,
The नाम बताइए.
Aman Kedia.
Mr. Aman Kedia, advocate, submits that the learned amicus is ill and in advance adjournment notice has been circulated with a prayer to close the matter in the next week. Post this case for final disposal on Monday. Court may the term "ya" is not to be used.
I'm sorry. Apologies. Apologies.
No, we all use it as a regular
I
conversation,
came out of.
but that is not a language to be used in the court.
I won't, it won't happen again.
So,
From supplementary list, targeted cases, item 1, 2nd April 7, item 2, 2nd April 97 or 2002.
IE notes, IE 10084 of 2025. IE notes for substitution. But defendant number, respondent number 3A have expired and his legal years are already on record. So 3A needs to be deleted.
any objection, respondent?
But I am for respondent number 2 and they will not for rest will not
And 3D
For
का मतलब
not,
legal years को notice आएगा.
proposed and not legal heirs to of respondent number 3D as well as respondent number 1 is required to be sent.
Respond number 1.
So
Yes.
1 and 3D का legal years को notice होना है. And notes 3A का नाम delete.
कौन-कौन है respondent number 1?
1,
3A is to be deleted.
3A to be deleted,
3D.
3D to be substituted and 1 to be substituted.
1 का legal heir का नाम है.
Yes, 1 का legal year का नाम है. But paragraph 5 में it has been stated.
Paragraph.
पंचम महत्व.
कितना है? 15-16 साल पहले.
But informative petition ये फाइल किए के बाद ही information.
ठीक.
That I have stated.
Please and पंचम में तो resident of certificate.
Yes. And notes 3D का paragraph 4 legal years.
3D is para number
4.
and 3A के बारे में
3A के बारे में note mentioned है paragraph 3 में. 3 है A expired and his legal years are already on record.
who are the legal heirs?
तो 3 substitute हुआ तो 3A हुए उनकी वाइफ एंड उनके बच्चे हुए. तो वाइफ का डेथ हो गया तो उनका नाम डिलीट हो जाएगा. And 3D is one of the sons who had expired, leaving behind his sons.
Second appeal number 97 of 2002 with IA number 10084 of 2025. The learned counsel for the appellant has submitted that the petition for substitution has been filed. With respect to respondent number 3A, 3D, respondent number 1, 3A, 3D. He submits that so far as 3A is concerned, her legal years are already on record, and therefore it would be suffice if her name is deleted from the first title. So far as respondent number 1 and 3D are concerned, the name of legal years and successors have been mentioned in paragraph 4 and 5 of the interlocutory application. The which are as follows, ठीक है? Legal years of 3D para 4 में है, and for respondent number 1 there is only one legal year, पंचम में. Let notice be issued to the proposed legal years and successors of respondent number 3D and 1 through the concerned police station for which request is filed by Friday. So far as respondent number 3A is concerned, her name be deleted from the cause title in view of the submissions made by the counsel for the applicant. उनका respondent का लिखिए. There is no objection so far as the. अभी तो
नहीं,
क्या है?
objection
He is
नहीं,
he is appearing. He is just
हमारा
appearing.
objection है अपने
You are for respondent number
2.
Counsel for the respondent number 2 is present. If so advised, he may file an appropriate affidavit in connection with the interlocutory application. बिना affidavit के कोई objection आपका नहीं सुनेगा. जो objection करना है affidavit में करना. Post this case on 1st of September, awaiting service to court under the same heading. Next case. IMP pending.
For hearing item 3, first appeal 13 of 2003.
Yes, what is it? Who has expired?
Substitution has been done pursuant to IA file written. The appellant number 1 died.
Okay, that substitution has been carried out.
Yes.
So
Carried
otherwise
out or not that we could see, but there is order of
there is an order of
Ah.
substitution.
That was on let us say 28 July 2025 order. Last.
Fair enough. Now you tell me that what is the matter about?
This arises out of a land reference.
Otherwise, it is ready for disposal.
Yes, it is.
It arises out of section 18.
30.
Section.
Section 30.
She is seeking a passover as per your circular, whatever you have circulated. He has not come to the court so far. Sorry?
On the way.
Or is it at the court? He is never late to the court. That is why I am asking.
Stuck some traffic issue.
यहाँ पे कौन एडवोकेट कब पहुँचता है हम लोग को पता है. Anyways, we'll hear it. It is being passed over. Call him at 12.
Item 4, second appeal 26 of 2003.
Who is for the appellant? Responding to their comments. Nobody appears on behalf of the parties. Pose this case to me.
Item 5, second appeal 4 of 2004.
In this case, since कल भी लिस्ट में था, we have contacted our clients, not one of the appellant have died. He is appellant number 2, not Rama Mehta.
So you can file a substitution petition immediately.
Lordship may keep it next week because I have told them to come on Sunday with all the details and wakalatnama because
What
they
is
are
the
appellants.
substantial question of law? Adverse position.
I'll check on Lordship.
Yes, this is order dated 17/5/2006.
That note is date is noted as the
ये कोई
order.
बात नहीं, आप इनको दिखा देंगे फिर इनको एक कॉपी प्रोवाइड कर दीजिए substantial question of law. इसको बिना कैसे? He will
That I will
provide-
note it down.
हो सकता है आपका मेमो ऑफ अपील से ही कोई मैच कर रहा Essay number 4 of 2004. The counsel for the appellant has submitted that appellant number 2 has expired. He has received instructions to file petition for substitution. Responding to the comment. As per the list, is anybody agree? Nobody appears on behalf of the respondents. Pose this case on Monday under the same. Monday नहीं कर Monday आप फाइल ही करेंगे
हाँ,
on Wednesday.
Wednesday.
लेकिन वो काउंसिल होंगे तब ना कॉन्फिडेंस है
And I refer to the special edition that this is item 8, second appeal 67 of 2019.
Yes, are you agreeing?
This is partisans, and I think the partisans will matter also. Yes, sir, and appeal has not been admitted also.
So they will send the notices.
Yes,
It can be referred to mediation.
yes.
essay number 67 of 2019. The judgment in ex parte.
There is concurrency of judgment also. Both total.
Other side नहीं appear होने से वहाँ से भी
हाँ
file.
वही चीज जब तक appear नहीं हुआ।
तो आप इसको ऑर्डर 41 रूल 11 में बहस करिए. क्या स्टेज है इसका? What is the stage of this case? Under order 41 रूल 11 में आएगा.
इसको नेक्स्ट में करेंगे।
Essay number 67 of 2020. Counsel for the appellant submits that this appeal has not yet been admitted, and therefore the respondents have not entered appearance so far. He submits that the matter may not be referred for mediation. As per the office note, the case was earlier running under the heading hearing under order 41 rule 11. Office is directed to place this case under order for hearing under order 41 rule 11 in the supplementary clause list on Tuesday. Six column again.
Six orders concerning. Item 9, second appeal 68 of 2019.
तबीयत खराब हो गई है
Essay number 68 of 2019. The learned counsel for the appellant seeks adjournment. Respondent is the one coming out of the hearing in was Are you ready for mediation? Can't hear you. Can't hear you. I can't hear you. क्या बात है? सुप्रीत कहाँ? Where is he? You please text it. Message में text करिए. Am I audible now? Yes. Are you ready for mediation? I can't hear you again. I can't hear you again.
Sound of
Right now, I am audible.
Yes. Are you ready for mediation?
Clients that contact me over your worship, I have no instruction in this matter, but probably will refer more.
Just a moment. ऐसे नहीं होता. ऐसे number 68 of 2019. Counsel for the applicant seeks adjournment. The counsel for the respondent has submitted that he is not in contact with the client and has no instructions. इनका appearance online record करेंगे. Considering the submissions, let this matter be placed on Tuesday in the supplementary cause list under the heading for hearing under Order 41 11. उस दिन तक तो आ जाएंगे ना? कई बार एडजर्नमेंट हुआ है कॉस्ट देकर, आज नहीं कर रहे हैं क्योंकि मीडिएशन के लिए लगाना है. अगले दिन नहीं करेंगे तो कॉस्ट हम लगाएंगे जरूर.
From tail list, targeted cases item 1, second April 19 of 2003.
Yes.
Is also arising out of a land acquisition reference. This is in terms of section 30. So far this appellant are concerned.
Case is ready for hearing.
Yes, yes, I will.
Next कोई दिन रखा है.
अच्छा सुनते हैं ना नेक्स्ट वीक रखेंगे.
Case
Will tender a short list of facts.
You have seen the substantial question of law?
Yes. I have quoted the substantial question of law there in this also. The second page. Second page at the bottom.
They are seeking oral gift.
They are seeking.
They are seeking oral.
They are seeking oral. I am just narrating the facts. There was land. The land was acquired for the purpose of BCCL.
Just a
Ma-
moment. You just give me the short background.
Yes. The
When was it acquired?
1984.
1984.
84.
Land Acquisition Act.
Yes, that was corresponding to one land acquisition case 38 of 1984-85.
Case number 38 of 1984.
85.
85.
Which finally culminated in an award.
Award was won.
Yes, that was in the year 16/6/1988.
16/6/1988.
And the award was prepared in the name of the present respondent.
02955. Mohan Goswami.
Yes, father of these respondents.
You were the plaintiff or you were the defendant?
I was the original applicant in the land reference case. When the award was made in name of Mohan Goswami, father of the respondent Anil Goswami. Then I made an objection by way of reference, by way of seeking for reference.
The appellant raised objection.
Yes, under section 30 of the Land Acquisition Act 1894.
Under section 30 of
The
LAR.
yes, 1894.
Then
Upon which the land acquisition reference case number 49 of 2000 was registered. 49 of 2000. It was registered in the before the court of the land acquisition judge at Dhanbad. Then in the said case, land acquisition reference case, it was found that the land is the Khatiani land of the present appellant. It stood recorded in the name of the ancestor of this appellant, the Khatian being Exhibit 3, the CS Khatian, cadastral survey Khatian.
CS Khatri. Genealogy is in dispute.
No, there is no. And accordingly, on the said findings about the title documents of this appellant, the first court modified the award and held this appellant entitled for getting the awarded amount.
Quantum was not in dispute.
No, quantum was not. Therefore, section 30.
What happened with
Then-
the first
then-
appellate court?
The learned first appellate court has came to a finding recognizing the oral gift on basis of circumstances and certain oral evidences. Though and accordingly on that basis reversed the judgment of the learned first appellate and the learned first court, that is the reference court.
And now you are in appeal.
Yes.
Just a minute. Learned counsel for the appellant. ये लिखिए. Essay number कौन सा है? 19 of 2003. Learned counsel for the appellant submits that this appeal arises out of land acquired way back in 1984 in land acquisition case number 38 of 1984-85. The award was prepared on 16/6/1988 for an amount of rupees 6029.45 in the name of Mohan Goswami, within bracket, father of the respondent. Respondent number 1. The appellant raised objection under section 30 of Land Acquisition Act, and the matter was referred to the Land Acquisition Court and was numbered as Land Acquisition Reference Case number 49 of 2000. The learned counsel submits that the first court held that the land so acquired was the Khatiani land of the ancestor of the appellant, as the name of ancestor of the Khatian was recorded in CS Khatian, and modified the award by holding that the appellant would be entitled for the compensation and not Mohan Goswami. He submits that the first appellate court has upset the judgment passed by the learned trial court, by the land acquisition court, and has recognized the oral gift, the alleged oral gift, on account of the circumstances discussed in the judgment. The learned counsel has submitted that in this background, the following two substantial questions of law have been framed for consideration. पढ़िए judgment पढ़िए.
The first
ये
reference court.
इससे मिलेगा, order dated 5/11/2003. First judgment.
Yes. That is have the present land acquisition case number arises out of the award number 99, land acquisition case 38/84/85 and 37/89/90 under section 30 of the land acquisition act 1890. The applicant's case in brief is that the land in question is situated in village Pandeti within PS Kadras, Topsaji district, Dhanbad, under Khata number 1, plot number 253, area 5 decimals, which comprises a house, stands recorded in the name of forefather of the applicant in the cadastral survey Khatian. The house has been acquired by the District Land Acquisition Officer Dhambal, acting as a collector, and the award prepared amounting to rupees 6029 and 45 paise in the name of Mohan Goswami.
Mohan Goswami is who?
The father of the present respondent number 1.
उस समय तो आप बोले अच्छा मोहन गोस्वामी.
Mohan.
That's right. Okay.
OP1, the father of the opposite party number 1, Anil Kumar Goswami. The other 2 to 4 opposite parties are the sons of opposite party number 1. The applicant filed a petition before the learned district land acquisition officer Dhambal and claimed the amount to be paid to him, upon which the learned land acquisition officer Dhambal referred this case and sent the application along with the Wakalatnama copy of the award and valuation khatyam to this court for proper ratification. The opposite parties appeared in this case and contended that the house in question originally belonged to Hari Mathur, who donated to the predecessor, their case, in interest of the opposite party for the purpose of worship in the year 1940. And thereafter the ancestor of the opposite party constructed a house over this land. The opposite parties have been residing in the house peacefully and without any interruption and acquired indefeasible title by adverse possession. The land acquisition department, while making an entry, found Mohan Goswami in possession over the land and house situated in plot number 253 and prepared an award in name of Mohan Goswami. After death of Mohan Goswami, the opposite party number 1 became the rightful owner of the house and is entitled to receive the amount of award. It has been contended by the opposite party that the case of the applicant may be dismissed and the award will be granted. The main question for determination in this case is whether the land in question belongs to Aradhan Mathur or to Anil Kumar Goswami, the opposite party number 1, and whether the applicant is entitled to get the amount of award after making correction there. Then the findings clarify. The applicant has examined as many as 4 witnesses in support of his case. On the other hand, the opposite parties have also examined altogether 4 witnesses in support of their case. It is admitted case of both the parties that the land in question over which the house was constructed originally belonged to Hari Mathur and the father of the applicant, Aradhan Mathur. It is admitted case of both the parties that the land in question over which the house was constructed originally belonged to Hari Mathur, the father of the applicant, Aradhan Mathur. The opposite parties have contended that the land in question was donated to the father of the opposite party number 1 and thereafter he acquired title over it by adverse possession. So onus lies on the opposite party to prove that they had acquired valid title by adverse possession as well as on the basis of the gift. Before dealing with evidence of any other witness, I would like to deal with first the evidence of Aradhan Mathur, applicant witness number 3, who is none else than the applicant himself. He has stated in his evidence that the land in question over which the house was constructed, situated in village Pandedi, was originally recorded in the name of the grandfather in the record of right. After the death of his father, the land in question has been acquired by the government on behalf of Messrs. Bharat Coking Co. Limited, but the award has been prepared in the name of others, which is wrong. He has denied the possession and title of the opposite party. He has supported his case. Ashok Kumar Mathur, applicant witness 1, Magan Mathur, applicant witness 2 are the material witnesses who have supported the case of the applicant. Hiren Kumar Mathur, applicant witness 4 is a formal witness who has proved 3 rentresses marked as exhibit 1 by B. On the other hand, I would like to deal with
Just
first
a moment. This particular person, the evidence of Haradhan Mehto, right? He claimed to be the son of
the son of Hari Mathur.
Hari Mehto. Evidence of Haradhan Mehto.
Paragraph
No, he is the
5.
applicant himself.
Yes, Haradhan Mathur is applicant himself.
Okay.
Para 5, the name of his father is there, Hari Mathur.
Son of Hari.
And the land is recorded in name of his grandfather, Pannu Mathur. That is exhibit 3. Grandfather of Haradhan Mathur.
Read para 7.
On the other hand, I would like to deal with first evidence of Anil Kumar Goswami, opposite party witness 4, who is opposite party number 1. He has stated in his evidence that the land in question originally belonged to Babulal Mahato, Pannu Mahato and Kalpu Mahato. Anil Kumar Goswami, opposite party number 4, who is opposite on an OP witness 4, who is opposite party number 1. He has stated in his evidence that the land in question originally belonged to Babulal Mahato, Pannu Mahato and Kallu Mahato. Applicant Hari Mahato is the son of Pannu Mahato. He has further stated that Hari Mahato and Chandu Mahato made oral gift of the land in question to his father in the year 1940-41. Thereafter, his father constructed a house and started living there. According to his evidence, it appears that there was no registered document in respect of the land in question. So there should have been a registered document in respect of the land in question. According to section 17 of the Indian Registration Act, as the amount of the award is rupees 6029 and 45 paise, no documentary evidence has been proved in respect of the oral gift. As opposite party number 4 has opposite party witness 4 has himself admitted in his cross examination at para 5 that no document of gift was prepared, and he came to know about the oral gift from his father and Hari Mahato. He has stated in his evidence that he has been residing in a house in question, but his evidence has not been supported by his other witnesses. There is no direct oral evidence also in respect of oral gift. Then Ghulam Rasul, opposite party witness 1, however, has stated in his evidence para 4 that Anil Goswami lives in the disputed house, while Nirmal Mahato, opposite party witness number 2, has clearly stated in his evidence para 4 that Anil Goswami lives in New Pandeti village. Thus, the evidence of the opposite party witness 4 and opposite party witness 1 are belied by these witnesses. Niku Singh, opposite party witness 3, has also stated that Anil Goswami has been living in the house in question, but his evidence also does not appear to be believable in the light of the evidence of opposite party witness number 3. Thus, the case of the opposite parties in respect of adverse position is not proved. The applicant has proved the rent receipts, which are Exhibit 1 series. Exhibit 2 is certified copy of deposition of Ghulam Rasul in criminal case number not mentioned, which is dated 1863. On perusal of this document, it appears that Ghulam Rasul, opposite party witness number 1, has deposed in a criminal case against the father of the applicant. Thus, he is inimical to the applicant. Hence, his evidence cannot be relied upon. Exhibit 3 is the certified copy of the cadastral survey Khatian. On perusal of this document, it appears that the land under Khata 1, plot 253, was originally recorded in the name of Pannu Mahato and others. This Pannu Mahato is the grandfather of the applicant. On the other hand, the opposite parties have filed the certified copy of the order in a miscellaneous proceedings case number 338 of 81 under section 107 CRPC, a provisional Rayati Parcha Exhibit B and CC of voter list Exhibit C. On perusal of Exhibit A, it appears that Subhas Mahato and others, the brother of the applicant, were bound down under section 107 CRPC, but this document is of no avail to the opposite parties, as it neither confers any title nor any possession. As regard Exhibit B, which is a provisional Rayati Parcha, I would like to observe that Rayati Parcha is not a document of title, rather it shows only possession, that is also not final. This Exhibit B has been issued in the name of Mohan Goswami, appears to be procured one, as it is not supported by any other documents. As regards the possession, which has already been observed in the discussion of the oral evidence, that adverse possession should not be proved by the opposite parties. In as much as for proving adverse possession, one has to prove uninterrupted possession continuously for 12 years. But the opposite party witness number 2 has already stated that Anil Goswami lives in New Pandeti village. That New Pandeti village is different than that of Pandeti village. Exhibit C, which is voter list relates to Sindri Legislative Assembly constituency. That does not make any difference. In view of the discussions made above, I find a rule that
That's the learned counsel has placed the judgment dated 12th of September 2001 in land acquisition reference case number 47 of 2000 and has submitted that it remained undisputed that the property under acquisition originally belonged to Pannu Mehto and others. The appellant hearing claimed who was the applicant before the court, namely Haradhan Mehto, claimed to be the descendant of the recorded tenant, and this aspect of the matter was also not in dispute. But the father of the respondent claimed the property by stating that he was given the property by way of oral gift by Hari Mehto, father of the applicant, and Chandu Mehto. An oral gift was given way back in the year 1940-41, on which they constructed a house and were living on the same. The learned counsel has submitted that neither there was any oral nor there was any documentary evidence to prove the oral gift, much less the oral gift was, much less there was no registered document to support the gift.
But it was acted on.
Just a moment. The learned counsel has also submitted that the learned trial court also considered the fact that the opposite party was not residing on the property, rather he had a different residential address at a different place. The learned counsel has further submitted that the evidence of one of the witnesses of OP number 1, namely Ghulam Rasool, was disbelieved by referring to his evidence in another case where he had deposed against the appellant,
father of the
against the father of the appellant. The learned counsel submits that after scrutinizing the materials on record, the learned trial court found that neither the gift was proved nor the adverse possession could be proved, as the basic ingredients for claiming adverse possession was also not proved by the father of the opposite party number 1, and ultimately it was held that the appellant would be entitled for the awarded amount of 6,029.45. Appellate court.
Yes, that is. I read from the findings.
नहीं आप पढ़िए findings से पढ़िए खाली point for determination.
हाँ, point ये just scoop वाला
हाँ,
para 6.
para 6.
On the basis of the pleadings and evidences, learned lower court has summarized the dispute in 2 issues: whether the land in question belongs to Haradhan Mehto or to Anil Kumar Goswami, opposite party number 1; whether the applicant is entitled to get the amount of award after making correction therein. Heard both counsels at length and perused the documents in record, it has been stated on behalf of the respondent number 1, applicant, that the land in dispute as well as the house constructed over that belongs to him, and he is living with his family in the house of Moja Pandeti. It is evident on the basis of the exhibit 3 cadastral survey Khatyan that the land in dispute is a Rayati land recorded in the name of Babulal Mehto, Kalpu Mehto and Panu Mehto. This fact has also been admitted by the appellant opposite party. Now it is to be decided that on the basis of ancestral land, whether the respondent appellant is living in that disputed house or on the basis of alleged gift, the appellant opposite party is living and maintain possession over the disputed land. This is the point formulated. Then PW1 Ashok Kumar Mahto has deposed that he knows the appellant as well as the disputed land of Pandedi Moja number 270, plot number 253, area of the land 5 decibel. This house is over the land which is ancestral property of Radan Mahto. Opposite party has no right or possession over the land which has been acquired. So according to this witness 1, the disputed land is ancestral property of the applicant, but nothing has been stated that the applicant is residing in the disputed house at present or not. In the cross-examination, however, this witness 1 has stated that the applicant Haradan Mahto is in service in Kandra, where he has been living for 20 years, which is in Sindri police station. According to witness number 2, Magan Mahto, he knows both the parties and disputed land. The disputed land is in the name of Haradan Mahto, on which Haradan Mahto has possession. The appellant opposite party has no right or possession over that. In his cross-examination, witness 2 has deposed that he knows Anil Kumar Goswami, who lives in Pandedi. His father's name was Mohan Goswami. He also lived in Pandedi and his house is in Pandedi. It has been further stated from the time he became conscious, he has seen Mohan Goswami living in that house. So after examination, both witnesses, the matter is still not very clear, as it has been stated by the witnesses that the applicant as well as opposite party both lives in the house situated in Pandedi. PW3 is Haradan Mahto, who has thoroughly confirmed his case. PW4 is Dhiren Kumar Mahto, who has proved revenue receipts. Exhibit 1, 1 by A and 1 by B are the revenue receipts, which shows that the revenue of the year 1990, 94 and 1989 were paid by the respondent applicant. It appears that on the basis of these revenue receipts, that the house and land in dispute are in the possession of the respondent applicant. According to OPW2, Nirmal Mahto, who is resident of Pandedi, he knows members are both the parties and disputed land, and house land is Khata 1, plot 253. Previously, this land was recorded in Khatyan in the name of Babulal Mahto, Kalpu Mahto and Panu Mahto. Panu Mahto's sons are led Hari Mahto and Chandan Mahto. Panu Mahto's sons are led Hari Mahto and Chandan Mahto. Kalpu Mahto had no son, and Babulal Mahto has a daughter whose name is Bijola Mahtai. She was his mother. He has heard from his mother that the disputed land has been donated to Mohan Goswami. He has heard from his mother that the disputed land is donated to Mohan Goswami. From the very beginning, he is looking the possession of Mohan Goswami over the land on which a house was built. After the death of Mohan Goswami, his son began to live in that house. The applicant Haradan Mahto is his sharer. Father of Haradan Mahto never lived in this disputed house. The disputed land was donated to perform worships. In his cross-examination, opposite party witness 2 has repeated that he knows the whole family of the applicant and about the every land they have. His father had told him that the disputed land was gifted to Mohan Goswami. However, in para 4 of his cross-examination, opposite party witness 2 has stated that Anil Kumar Goswami works at Tetulmari Colliery and he lives in New Pandedi, Basti. The ancestral property of the Anil Goswami is at Chandan Kari. Opposite party witness number 1, Ghulam Rasul has stated that he knows both the parties and the disputed land which is in Pandedi Moja, Khata 1 plot 253, and the area is 5 decibels. A house is situated on the disputed land. This disputed house has been built by Mohan Goswami. This land was previously recorded in the name of Babulal Mahto, Kalpu Mahto and Panu Mahto. They donated disputed land to Mohan Goswami because he was a Pandit. The house was built after the donation. Aradhan Mathur and his father never lived in that house. Mohan Goswami died. After the death after the death of Mohan Goswami, his son Anil Kumar Goswami is living in that house. He also has a house and land in village Pandeti. In cross-examination, the opposite party witness number 1 has stated that he has deposed against the respondent applicant in a case in 1961-62. Opposite party witness Niku Singh, resident of Bandeli Basti, has deposed that he knows the parties on the disputed land which is situated in Bandeli Basti. Anil Kumar Goswami lives in that house. He is looking Anil Kumar Goswami living in the house since his childhood. Anil's father was Mohan Goswami. He has seen into, he has also lived in the house. Opposite party witness he has mentioned the boundary of the disputed house, that in the north temple, south mine, east villa and west house of Subhas Mato and a garden. Subhas Mato is own brother of Aradhan Mato. Aradhan Mato and his father never lived in the disputed house. His own house is in Pandedi. Opposite party witness number 4 is Anil Kumar Goswami himself, who has fully supported his case in his deposition. So, on the basis of depositions made by the opposite party witnesses, it appears that the appellant opposite party Anil Kumar Goswami lives in the disputed house which is in Pandeti Moja and which was donated by the ancestor of the respondent applicant. This fact has been supported, which exhibit B. Exhibit with the original Parcha of Moja Pandeti number 270. Exhibit A also supports the fact. It is an order passed by the executive magistrate in a proceeding under section 107 CRPC, which was filed between Mohan Goswami and Subhas Mato. Mohan Goswami to maintain peace. In this order, the landed magistrate has concluded that the cause of the breach of peace was a dispute for the ownership of a house to which both the parties claimed their right. Now I would like to deal with the deposition of applicant witness number 1 Ashok Kumar. The witness, who admits that the disputed land is an ancestral land of the applicant, he says that Aradhan Mato lives in Kandra since 22 years, where he is in service. The applicant witness to Mohan Mato has stated that Anil Goswami lives in Pandedi and his father Mohan Goswami also lives in Pandedi. This witness also not stated categorically that Aradhan Mato lives in Pandedi. Exhibit C, which is a voter list, also shows that the name of Aradhan Mato is given in the voter list of Sindri constituency of Legislative Assembly. Considering these facts, I find that though no document of gift was prepared, it has been proved by evidences produced that the appellant's father built the house in dispute over the land. The appellant is living in that house since long period. The Rayati Parcha, which is exhibit 2, do not confer any title, but it proves the instant possession of the applicant. There is no basis to prove that this Parcha was procured by the applicant.
Elsewhere. What is the date of order passed in 107 proceedings?
That is dated. That's the exhibit. 83 4/3/1983.
This is CRMP case number 338 of 81.
And case number.
And order of date is?
Dated.
Date of order?
Last week mentions 4/3/83, whether it is the date of issuance of certified copy, because no other date is there. And in top with pen there is a date 18/9/93.
I don't find a copy of that order.
It is this copy is
Yes, yes, yes. This one.
Balance sheet is 18/9.
This is case number 338. 338 of 81.
19.
देखिए जरा. The learned counsel for the appellant has also placed the judgment passed by the first appellate court in title appeal number 54 of 2001. And he submit that the point to be decided has been recorded in paragraph number 7 of the appellate court's judgment in the following manner. Quote to me. Now it is to be decided that on the basis of ancestral land, whether the respondent slash appellant is living in that disputed house, or on the basis of alleged gift, the appellant slash opposite party. बहुत अजीब तरह से लिखा है.
language.
और
I
problem.
was reading.
Anyways. ऐसे लिखिए.
Somewhere the sentences are
Has referred to paragraph 9 and has submitted that the point for determination has been recorded therein. He has submitted that the learned first appellate court has recorded that it was a case of the that as per exhibit 3 CS Khatlian, the land in dispute is Rayati land recorded in the name of Babulal Mehto, Kalpu Mehto and Pannu Mehto, which stood admitted. And the point to be decided was as to whether the descendant of recorded Rayat was living on the property or the Anil Kumar Goswami, who was the appellant before the first appellate court, was living on the property. है ना?
Initially, his father, Mohan Goswami, was living.
That's
After-
all his and his ancestors were living on the property.
since the year
Just a moment.
1941.
The Learned Council has submitted that the Learned First Appellate Court has recorded that the applicant, who is the appellant before this court, was living in Kandra since 20 to 22 years, as it had come on record that he was in service. Service mein tha na?
Service.
He was in service. And has also recorded that the house over the property was built by Mohan Goswami, but no objection was raised. And such house was built on the land donated to Mohan Goswami. The Learned First Appellate Court has recorded that the evidences prove that Mohan Goswami was in possession of the property. The Learned Council has submitted that the dispute between the parties was already existing in as much as a proceeding under section 107 had taken place and parties were directed to maintain peace. The Learned Council has also submitted that there is no finding recorded as to on which date the possession of the father of the respondent number 1 or that of respondent number 1 became adverse to that of the appellant Haradan Mehto, who is the descendant of the recorded tenant. The Learned Council submits that the basic ingredients for adverse possession has not been recorded in the new judgment, and therefore the second substantial question of law is to be answered in favor of the appellant. The Learned Council has also submitted that there is neither any oral nor any documentary evidence with regard to gift. The gift is sought to be, the gift is oral gift. The alleged gift is oral gift and there is no witness to the oral gift. And merely on account of possession, the impugned judgment has been passed by the Learned First Appellate Court while reversing the finding of the Learned. How to put it?
one more point. It is their case that it is a case permissive possession, that they were in permissive possession. If when one makes out a case of permissive possession, in such case he cannot claim adverse possession.
The learned counsel has also submitted that the plea of oral gift at best can be said to be a case of permissive possession. And once the respondent number 1 or his father had taken a clear stand that they were in possession by way of oral gift, there is no question of any adverse possession. As such, plea is self-contradictory and both the pleas are not permissible to be taken in that sense.
Because the possession will not be hostile to the knowledge of the original owner.
That's all. Judgment लाया है कोई?
On this point, we have not brought any judgment on this point because our basic case is that this learned appellate court has also recorded a finding about our ownership. There is no dispute about our ownership, and only thing is that on basis of a finding of possession, that too mainly based on the evidence of opposite party witnesses. If not, let us say kindly sees paragraph 11, the conclusion of the learned appellate court, paragraph 11. So on the basis of depositions made by opposite party witnesses, their witnesses, it appears that the applicant opposite party lives in the disputed house which is in Pandeti Moja and which was donated by the ancestor of the Jharkhand family. So it is merely on basis of their witnesses this finding has been reported. And moreover, one factual aspect, if para 9 is seen, internal page 4, para 9. Para 9. The findings on basis of the revenue receipts. The first sentence is exhibit so and so are the revenue receipts which shows that the revenue of year 1990, 94 and 89 were paid by respondent applicant. It appears that on the basis of these revenue receipts that the house and land in dispute are in the possession of the respondent applicant. Here is a finding on basis of this.
In your favor?
Yes, in our favor. This is one finding.
The exhibit 1, the learned counsel has also submitted, has also made reference to paragraph 9 of the impugned judgment passed by the learned first appellate court to submit that the revenue receipts, but they are all post-acquisition.
What happens?
They are all post-acquisition.
Post-acquisition, what happens? The mutation record register is not maintained. After once it is acquired, acquisition notification is final, that there should be corresponding corrections.
Has submitted that altogether 3 revenue receipts were produced to show the possession of the appellant. Although all the revenue receipts were after the date of acquisition.
And one more thing, one legal aspect, that so far as payment of compensation, a person found to be dispossessed merely because a person found to be in possession, at best their highest case, that they were found to be in possession as per their own case, that cannot make one entitled for compensation until unless they have certain semblance of title.
The learned counsel has submitted that the compensation has been awarded in favor of the respondent number 1 primarily on consideration of their possession. He submits that mere possession is not sufficient to claim compensation unless they have a semblance of title by way of, or they have perfected their title by way of adverse possession, whose basic ingredients have not been satisfied in the present case, and the stand is also conflicting as they were at best in permissive possession. आप बताइए क्या बताना?
और एक दो पॉइंट पहले लीगल पॉइंट बता देते जो फाइंडिंग्स है इसमें पैरा 13 में there is a specific finding. I find that though no document of gift was prepared, so it is a finding of the learned first appellate
There is
court.
no doubt on that. Please, Mr. Banerjee, एक चीज को 4 बार मत बोलिए. हाँ बोलिए. Yes, respondent.
हाँ.
क्या बोलिए?
In fact, the respondent one was in possession. Therefore, the taking into consideration his possession.
let us focus on the substantial question. Let us see the first one. पढ़िए. First one.
First one. That the rule has added both on facts and law.
Then first question of law. Mr. Banerjee, you help him out. He does not have the question of law. Yes, please read that.
Whether the defendant or his father Mohan Goswami acquired title by virtue of oral gift by ancestor of the plaintiff, who was one of the recorded tenants of the suit.
But then,
So on this point,
can anybody get title by way of oral gift with regard to immovable property?
in the peculiar fact of this case,
फैक्ट से नहीं चलेगा सर, आप लॉ से बताइए. रजिस्ट्रेशन एक्ट कब बना था? इंडियन रजिस्ट्रेशन एक्ट 1908. ठीक है, उसके बाद तो ट्रांसफर ऑफ इमूवेबल प्रॉपर्टी विदाउट रजिस्टर्ड डॉक्यूमेंट नहीं हो सकता है. और डॉक्यूमेंट से भी अगर होगा तो इफ इट इज लेस देन 100 रुपीस वैल्यू देन ओनली इट नीड नॉट बी रजिस्टर्ड.
take into account this fact that the only 5 decimals of land, that too it was granted to the
ऐसा कोई
priest.
रजिस्ट्रेशन एक्ट में लिखा है कि
Priest.
अगर एक रजिस्ट्रेशन एक्ट में अगर एक 1 स्क्वायर फीट लैंड इज आल्सो ट्रांसफर्ड and if it is valued more than 100 rupees it has to be registered.
Since it was
अब
oral
डिसमिल
gift,
की क्या बात कर रहे हैं?
But
1
since-
square inch,
since
1 square inch of land to be transferred, it has to be compulsorily registered. It is compulsorily registerable. There is no qualification कि इतना होगा, 5 डिसमिल से ज़्यादा होगा तब रजिस्ट्रेशन. ऐसा कोई है कि सर्कुलर झारखंड के लिए स्पेशल? ओरल गिफ्ट कैन इट बी रिकॉग्नाइज्ड? आप एज ए काउंसिल बताइए ना, आप छोड़िए ये सब.
since it has come in evidence that the Aradhan Mata was residing in Pandra.
आप आपका घर कहाँ है?
He was not.
You belong to which place?
No, I know that.
No, you belong to which place? आप बताइए एज ए काउंसिल आप कहाँ के रहने वाले हैं?
No, है तो हम
कहाँ के?
डिस्ट्रिक्ट पुरुलिया पड़ता है.
पुरुलिया. तो वहाँ का आपका जमीन होगा तो क्या एडवर्स पोजीशन हो जाएगा किसी का?
ऐसा नहीं, ऐसा
है ना?
some
Somebody might be living for a reason. नौकरी में है तो बाहर ही रहेगा ना. नौकरी में है तो बाहर रहेगा ना.
in fact it was adverse position, by way of adverse position. Basically it was oral gift and permissive position is there, that is there. It was gifted to the priest, only 5 decimals of land, and he was possessing the land. He constructed house, was residing there. Everything is there in regarding possession. Therefore, the when the land was acquired for BCC, what was passed?
For substantial question of law में तो कुछ भी नहीं आपके फेवर में. How can there be a transfer of land by oral gift? Oral gift खाली हिबा में चलता है. Are they governed by Muslim law?
That is not there. But
गोस्वामी नाम है ना, मुस्लिम लॉ का कोई स्कोप ही नहीं दिखता.
but so far the witnesses they have discussed these things that it is the respondent who was residing there after constructing the house thereafter.
The learned counsel for the respondent, while answering to the first substantial question of law, has submitted that there is enough evidence on record that there was an oral gift with respect to the property, and those evidences are sufficient to hold that the respondent number 1 or his father was at least in permissive possession of the property. He submits that the oral gift has been sufficiently established.
Now I am coming to the judgment.
Second, judgment.
Appellate court judgment. Appellate court judgment in finding in para 7. But
Para 7 is not the finding, that is the discussion.
discuss.
The finding comes in para number 13.
So discussion, sufficient discussion has been made on the point of possession.
Para 12 may be, 12 may.
12 maybe here. Like this.
In fact, para 13 is the finding. Considering these facts, I find.
Now I would like to deal with the position of AW1, Ashok Kumar, witness through.
So para 13 may I see the para 13 is the finding.
Considering these facts, I find that though no document of gift was prepared, it has been proved by the evidences produced that the applicant's father built the house in dispute over the land, and applicant is living in that house since long period. Rayati Parcha, which is exhibit 2, though not confirm any title, but it proves that the purchase procured by there is no basis to prove that these purchases are procured by the applicant. It has been proved again that after the donation, the house was built by Mohan Goswami, and no objection was raised by the respondent, appellant, and fact also proves that a donation was made in favor of him. So, next,
The learned counsel for the respondent number 1 has referred to paragraph 13 of the first appellate
And
court
14
judgment, particularly paragraph 13 of the first appellate court judgment, to submit that it has been clearly recorded on the basis of materials on record that a donation was made in favor of the father of the respondent number 1.
and he was
And he was in possession of the
appellant
property
was-
and constructed a house over the property.
an appellant was never found in possession of the land.
And the appellant was never found in possession of the land.
Rather, the witnesses have stated that they reside in a place, Kandra.
Is there any finding that since when he was residing at Congress, 20 to 22 years?
22 years. And it is the respondent number 1 and others. They were residing in the place. So, it is clear on the point of oral evidence that the appellant was never in possession. Rather, they were in possession after having built the house from the year 1940 to 41. And the 14 also it has come, and lower court has decided only for some years in village New Pandeti. New Pandeti, after development of mines, Pandeti, New Pandeti, that is the same. There is not a far away place. New Pandeti village, which is different village, the finding is not correct because no one has proved that a New Pandeti is a different village. So it was the same village. So, point of position, the respondent case is proved. This finding that voter list of Sindri Legislative Assembly, this is under Katras.
There are two villages, one is Pandyadi and other is New Pandyadi.
No, it has not been proved. That is why in
No one has proved that New Pandyadi and Pandyadi are the same village.
नया घर बना उधर तो नया न्यू पंडित कहा गया, otherwise it is pandit. And this finding that the voter list of Sindri Legislative Assembly constituency does not make any difference is also not correct.
ये वोटर लिस्ट किसका था?
इस
Whose
एरिया
voter list was that? आपका कि उनका?
उनका था। वो सिंदरी विधानसभा के अंदर में कांड्रा विलेज में वो रहते थे for the last 20-22 years.
ठीक।
So this big piece of land, it comes under Katras constituency. So depending the voter list in the assembly constituency does not make any difference in the voter is also correct. The name of person cannot be inserted in voter list of the constituency without living there permanent, living there permanently. And this fact has also been supported by AW1, who is clearly stated that respondent applicant live in Canberra since 20-22 years. And these evidence, facts and oral evidence used by the parties your vote or the agreement was got every right, every interest over the land in question and the rather market allowed on the point of adverse policy. We need is not a case of permissive position, rather already after giving the oral he was reconstructed house, he
The
was
learned
residing.
counsel for the respondent has also submitted that the case is not a case of permissive possession, rather it is a case of adverse possession. As the father of the respondent number 1 had constructed house over the property,
Commercials are also
and witnesses have supported that
at time of position
they were living on the property. Yes?
and the appellant was not in possession of the land.
And appellant was not in possession of the land for last 20 to 22 years, right? अच्छा एक सेकेंड ये AW1 कब एग्जामिन हुआ? What is the date of examination of AW1?
5/5/2001.
5/5/2001. He says 20 to 22 years. कितना हुआ? 20 साल पीछे कर दीजिए.
लगभग वही 1978, 78, 79.
78. Acquisition कब का है?
एक्विजिशन है ये 1984 में एक्विजिशन केस
1984. तो 78 से 84 12 साल हो गए.
बेसिकली इनका केस ही है कि हम
एडवर्स पोजीशन का 2-3 जजमेंट किए हैं ना. कौन सा एक मेजर जजमेंट है उसमें बोला कि कॉन्फ्लिक्टिंग स्टैंड नहीं ले सकते, है ना? निकालिए सर.
Witness for the appellant, Gulam Rasul. He has also supported. He was not a
गुलाम रसूल का तो उसको मतलब रिजेक्ट कर दिया उसका एविडेंस को. गुलाम रसूल वाज एन इंटरेस्टेड विटनेस. देखिए. The learned counsel for the appellant, the respondent number 1 has submitted that AW1 has stated that the applicant, that the respondent number 1 and his father was living, the AW1 has stated that the applicant who is the appellant before this court has been living in Kandra since last 20 to 22 years, and therefore there was a clear case of adverse possession made out in the case. In response, the learned counsel for the appellant has submitted that AW1 was examined on 5/5/2001,
Yes.
and if 20 to 22 years is counted back from that date, it would come to 1978, and the acquisition of the land in the present case is of the year 1984. And from 1978 to 1984, 12 years had not elapsed. The Learned Counsel has submitted that there is no finding recorded as to when the title of the respondent number 1 had become adverse to that of the applicant. And in absence of that, the respondent number 1 cannot claim any title on the basis of adverse possession. This is over and above the fact that the respondent number 1 had taken conflicting stands before the court. One is by way of permissive possession of donation/gift, and other is that of adverse possession. That's all.
Yes. And the finding in the MP case that the applicant, that is the respondent, was in possession. That finding is there in the MP case.
NP case is what case? That's 107.
107.
107.
107.
कहाँ है फाइंडिंग पड़ी? ऑर्डर का डेट नहीं पता चल रहा।
एक खाली लास्ट में देखिएगा वो सर्टिफाइड कॉपी इशू करने के लग रहा है वो डेट।
हाँ, 18 सर्टिफाइड कॉपी इशू करना पड़ेगा।
कोर्ट रेटिंग।
हाँ, कहाँ है फाइंडिंग?
Finding para 7 onwards.
इम्पोर्टेंट ये है कि 107 में there was a dispute. You cannot say adverse possession के लिए it should be absolutely peaceful, uninterrupted, hostile. But once the person is raising a dispute,
At the same time,
uninterrupted and hostile or is नहीं.
but at the same time, it is to be considered whether the person who are living in Kandra, in a far away place, so how they will be in possession of the piece of land where the this respondent after constructing
कोई
a
तो
house
आपसे
has
पूछे आपका पुरुलिया का सब जमीन you are not in possession. चलिए ये रखते हैं.
रविंद्र कौर गिरेवाल 2019
आप तो जजमेंट नहीं लेके आते तो हम क्या कर सकते हैं, इसीलिए नहीं तो अभी लिखा दो.
हम लोग फैक्ट्स पर ही हम लोग गए कि वो टोटली परवर्स है लर्नड
अपील इज अलाउड. हम रीजन दे देंगे. चलिए
और एक चीज लेडीज देखेंगे क्योंकि अपीलेट कोर्ट क्या किया कि उनका टाइटल भी डिक्लेयर कर दिया. टाइटल तो डिक्लेयर ही नहीं कर सकते.
आई गिव द रीजन. आपका सबमिशंस रिकॉर्ड कर दिए कंप्लीट है ना.
आई हैव गिवन द शॉर्ट नोट्स विद द रेलेवेंट फैक्ट्स पॉइंट लिस्ट.
आपका जूनियर काम नहीं कर रहा है. जजमेंट कोर्ट में किसका काम है? हाँ मिस्टर बैनर्जी, हम तो उसको अमेरिका से अपॉइंट करने का सोच रहे थे. कैसे अपॉइंट करेंगे? आई कांट बिकॉज ही इज नॉट वर्किंग. आई कैन सी हु आर वर्किंग. इतना अच्छा पढ़ाई किया है,
एक्चुअली
पढ़ता नहीं है.
इन दिस केस आई डिड नॉट आस्क हिम टू अरेस्ट.
Why should you not? Why should you not? Merely because it's a case of engagement. तब हम लोग को क्या जरूरत पड़ा अमेरिका से अपॉइंट करने का? We don't need any assistance. जो अपने चेम्बर का केस नहीं पढ़ता वो हमारा केस क्या ही पढ़ेगा. चलिए नेक्स्ट केस कॉल करते हैं.
So case from supplementary list item 3, first appeal 13 of 2003.
Yes, madam. अब कोई पास ओवर नहीं होगा मैडम, 2 बार पास ओवर होगा. चलिए अब ये बहस करना शुरू. Sorry? You better not be. For that, the case will not remain pending. You have the file? Open it.
In this case, we have submitted a short list of dates in the previous
Very
occasion.
एक बार DFD हो चुका है ना, ये 2-3 बार हो चुका है. दो बार DFD हुआ है. फिर से DFD कर दें. पढ़ाई करिए, पढ़ाई स्टार्ट कीजिए. No steps were taken.
Therefore,
फिर क्या है?
it was
Yes,
it was a reference under section 18 on their application, and this reference was made in the year 1990. And that reference, upon that reference, the reference case was instituted, which has been dismissed for non-prosecution in the year 2003. And from the order sheet, we have found that as many as 25 dates, they have not taken any steps in that reference case.
कुछ नहीं है ये. रेफरेंस करा के आप सो गए. Yes. What grounds have they taken?
They are basically taking a pleading that they were pursuing the matter, and in fact that is not intentional or willful. That is one limb of their pleading, which it appears. And the other
If the
thing,
case is dismissed for default, then under such circumstances you will have to file a restoration before the same court. You have a remedy under law.
here that it is not simply dismissed for default. The learned court has also recorded a finding. If that
Yes,
order
Mr.
It is a
Sani
case for
mentioned it.
dismissal for default, but the remedy provided under the law will not either to file a restoration, it will be easier. But at that time, my client did not instruct me properly, and then I preferred the appeal. But that is there, I can't deny this fact. But in fact, my lord, since the proceeding reference was made in the year 1990, in between, he attended for more than 10 years. Thereafter, the DVC was included as a party. I brought on record the entire certified copy of the order by way of supplementary affidavit. Although the lower court record is also most probably there. But your lordship will find from the order sheet,
Against whom are you fighting?
against the only reference has been made for enhancement of the land acquisition. The compensation amount for the land acquired for DVC, payment DVC has paid the amount to the state, and the state is required to pay the enhanced amount. Whether it could be enhanced or not, that is the subject matter of the land reference case. Under section 18 of the old Act, LA Act, not 1894. That is the only case. No dispute with regard to this. Land reference case will be decided either way. No merit has been decided. It is the reference was made. You will may kindly see the first page of the order sheet at page. I have annexed the entire order sheet, and the annexer 1 is the petition under section 18 of the Act. That was LA case number 80/81. This application was made under section 18 of the old Act on 9/4/1984. Thereafter, after 6 years, long 6 years, then on 27/1/1990 at page 10 of the supplementary affidavit, the reference was made.
मैं negligent का कुछ नहीं सकता.
So 10 साल हो गए हाजिरी I can show from this order sheet. Thereafter on his application on the objection raised by the state
10 साल क्या यहाँ पे भी तो हो गया 20 साल.
जो रही अब उसको मुश्किल से जो 2000 रुपया दिया था वो 20,000 होता.
आपने कहाँ अपना एप्लीकेशन फाइल किया था एनहांसमेंट का? What was your application for enhancement?
Yes,
आपने
that
कुछ
is
file
annexure
किया?
1. Annexure 1 to the supplementary bill itself. Section 18, page 7. Page 7. Supplementary filed on 19/5/2018. Annexure 1, page 7. Got it?
Yes.
The humble petition under section 18 of the LA Act. Grounds, classification made in the notice under section 9 of the LA Act totally false. The classification on the basis of the survey settlement record, which was prepared in the year 1928, that the valuation fixed by the LA department is also low and unsatisfactory, that insufficient, the market value of the land has not been fixed according to the market value prevailing in the area. The land is homestead land. The land acquisition department Dhanbad has fixed valuation of land of rupees 2 lakhs per acre, that is 2,000 per decimal. That the
कितना लैंड एक्वायर हुआ?
ये हुआ है 71 decimal, 1.5 लाख उनका compensation. 71, yes, खाता number, plot number 805, खाता number 90, area is 71 decimal. And Moja, Dukatan within Charia police station in the district of Dhanbad.
आप ऑर्डर शीट दिखाइए. आई एम अदरवाइज नॉट सैटिस्फाइड. ये सब ग्राउंड पर
Your Lordship, just see-
लिटिगेंट का हम लोग कुछ नहीं कर सकते.
Annexure 2 is the order sheet.
But
First page is on page 10.
there is a reference.
Yes, 21/1/1990.
Yes.
Yes, thereafter your Lordship will kindly take
No step.
first date 16/11.
No step.
अब उसके बाद तो
अब पढ़ते जाइए एक के बाद एक.
upper applicant takes no step, office to issue notice upon the parties by 16/12/1990. क्योंकि वो जो डायरेक्ट आया एलए से, हम लोग पिटिशन दिए थे वो एलए के पास, लैंड एक्विजिशन ऑफिसर
That's
पास.
right.
ये अचानक आया तो फिर नो स्टेप. देन नोटिस वाज डायरेक्टेड टू बी इशू. देन 16/12 एडजॉर्न हो गया. लेटर ऑन एप्लीकेंट अपीयर फाइल सोकालतनामा, that is on 19/12/1990. Later on. Then your Lordship kindly see 17/191 filing Hajri, 31/191 Hajri. OP takes no step. Then 13/291 Hajri, 7/391 Hajri.
एक सेकंड रुक जाइए.
11/4 बड़ा 12/2/21 7/3/91 सॉरी 12/2/91 7/3/91 11/4/91 26/4/91 14/5/91 4/6/91 25/6/91 6/7/91 नो स्टे 6/7/91. देन 2/8/91 हाजिरी 13/8/91 हाजिरी 13/9/91 टेक्स नो स्टे. देन 7/11/91 हाजिरी. देन 15/2 ड्यू टू एनजी स्ट्राइक. देन 3/3/92 हाजिरी. देन 3/4/92 रिकॉर्ड पुट अप टुडे एप्लीकेंट फाइल्स हाजिरी. 27/4/92 हाजिरी. 18/5/92 हाजिरी. 29/5/92 हाजिरी. 15/6/92 हाजिरी. देन 28/7/92 नो स्टेप. देन 3/9/92 पार्टीज टेक नो स्टेप, दोनों पार्टी. 11/11/92 पार्टीज टेक नो स्टेप. 8/12/92 नो स्टेप, 18/1/93 नो स्टेप, 23/2/93 नो स्टेप. Then applicant files petition praying for time. डेट मिल गया 11/6. तो एप्लीकेंट फाइल्स हाजिरी 11/6. 23/7 को स्ट्राइक, 23/9/93 हाजिरी, 14/12/93 हाजिरी, 20/1/94 हाजिरी, एटेक्स नो स्टेप, 21/3/94 नो स्टेप, 27/4/94 नो स्टेप, 24/2/95 रिकॉर्ड पुट अप टुडे, टेक्स नो स्टेप, 30/5/95 रिकॉर्ड पुट अप टुडे एप्लीकेंट नो स्टेप. देन 11/7/95 नो स्टेप. देन 28/8/95 हाजिरी, 9/11/95 हाजिरी, 4/1/96 हाजिरी, 27/2/96 नो स्टेप, 30/5/96 नो स्टेप. देन 29/4/97 प्रस्तुत किया गया उभय पक्षों की वकालतन हाजिरी. 3/9/97 राज्य तथा वादी की ओर से हाजिरी दी गई. वादी तरफ से एक आवेदन अंडर ऑर्डर 1 रूल 10 सीपीसी के तहत शपथ पर दाखिल किया गया, जिसकी प्रति राज्य के अधिवक्ता को प्राप्त कराया. पीठासीन पदाधिकारी अवकाश पर. 10/7/97 राज्य और वादी की हाजिरी. 22/8/97 हाजिरी, 13/11/97 हाजिरी. देन 8/1/98 हाजिरी, 27/2/98 हाजिरी. No step on behalf of the applicant and opposite party has been filed. Then 22/4/98, 21/5/98, the petition was disposed of, including DVC as a party. Then 1/9/98 हाजिरी, 10/7/98 हाजिरी, 10/8/98 हाजिरी. Then 6/11/98 हाजिरी. Then transfer comply the previous order 7/5/99. Then 18/5/98 हाजिरी, 9/7/99.
DVC entered their appearance.
Yes.
When did they?
It does not appear also. It does not appear so. Both parties declared.
Notice हुआ था DVC को?
हम जिस order हुआ.
Is allowed office to add. Office to add only.
Yes.
Square notice.
To issue notice. 10/7/98.
10/7.
जी. On record, the office to issue notice OP and put up on इतना. Then office को बोला कि comply कीजिए 10/8/98 को. फिर 8/1/98 को बोला comply कीजिए. 12/3/99 को बोला ऑफिस टू कंप्लाई. उसके बाद 18/5/98 पूर्वादेश का पालन. 9/7/99 पूर्वादेश का पालन. और ऑफिस उनका ऑफिस का है ये दोस्त. 2/9/99 हाजिरी. देन 1/12/99 पूर्वादेश का पालन करें. ड्यू टू
At any point of time, it was not placed for evidence of the
yes
applicant.
waiting for
appearance.
service.
Waiting for service.
That is the reason why it was at an immature stage. And within time it was referred under section 18.
If the opposite party is not appearing, the matter can be set
Could have been ex parte.
and then the evidence could have been called. But no
Could
such
have been,
procedure
but
has
no
been.
such prayer was also made. I
Yes,
agree.
respondent, what do you say? What is the procedure?
So far as
He
matter-
has read the entire order sheet.
the matter has to be heard in accordance with the procedure, because the procedure of the emphasized in the civil procedure
Yes,
That's
has
right.
to be followed.
My learned
Has to
is
be followed. And it appears after implement of DVC as party, thereafter it is not apparent as to whether notices
Yes.
are served.
He is
So-
also correct.
So, and you see, there are two things. If a party does not appear, then the court will set the
Would have
proceeding ex
proceeded.
parte and then ask the applicant to
Lead
file
evidence.
lead evidence.
There is not fixed for
No
hearing.
such order.
No such order is
No
there.
such order.
कौन है और साथ में आपके कौन है?
In this case, state is represented by I think Mr. Manish Kumar.
If they are not there, we don't bother about.
I represent the respondent number 2.
That is DVC.
Yes.
ठीक है। अब आप लोग अपीयर हो जाइए भाई, इसको रिमाइंड कर देते हैं, आप अपीयर हो जाइए।
उसमें जो अपरेंट नंबर 1 उनका मृत्यु होने से हम सब्स्टिट्यूशन दिए, लास्ट डेट में अलाउ हुआ है। देयर आर 2 अपरेंट्स, तो उसमें उनका सब्स्टिट्यूटेड लीगल हेयर्स हैव बीन प्लेस्ड ऑन।
आपने नाम डाल दिए ना, उन्हीं का ही नाम आए।
राधा देवी लिस्ट में छप
लिस्ट में डाले क्या?
हाँ आ रहा है, शायद उसमें करेक्शन हुआ।
देखिए फर्स्ट अपील नंबर 13/2003। स्टेट की तरफ से कोई नहीं है ना? Heard the learned counsel for the appellant and the learned counsel appearing on behalf of respondent number 2. This appeal has been filed against the judgment dated 20/11/2002 within bracket decree signed on 9/12/2002, passed by learned sub-judge second cum land acquisition judge Dhanbad in land acquisition reference case number 105 of 1990, whereby the reference has been answered by whereby the award given by the district land acquisition officer under section 18 of the Land Acquisition Act has been upheld. The learned counsel for the appellant has
Award is under section 12. 18 is the objection.
यहाँ पे जो लिखा है वही हम देखें।
हाँ वो गलत है।
या
Award होता है
ऐसे लिखिए the award passed by the district land acquisition officer Dhanbad has been confirmed.
मतलब I think the learned NA judge was meaning to say that he has exercised power under section 18
Okay.
of the act to confirm that award.
Yes.
That is done.
Yes.
Has been confirmed by exercising power under section 18 of the Land Acquisition Act. The learned counsel for the appellant has referred to the entire order sheet of the learned court and has submitted that the reference was made to the land acquisition judge Dhanbad and it was instituted as land acquisition reference case number 105 of 1990 under section 18 as back as on 27/11 no 27/10/1990. He has submitted that the notices were issued and the appellant had entered appearance by filing wakalatnama
17/12/1990.
on 17/12/1990 and thereafter on various dates he has been taking steps and filing his attendance / hajri and the respondents remained absent. He has further submitted that on few dates no steps were taken, but after a long gap of time, a petition was filed by the appellant on 3/9/1997. The petition dated 22/4/1998.
Yes.
So on 22/4/1998, seeking addition of party, whereby under Order 1 Rule 10, with a prayer to implead DVC, Bhavani Bhavan, Alipur, Calcutta, on the ground that the amount of compensation that the land was acquired for DVC and the amount of compensation has to be ultimately borne by DVC. The said petition was allowed on 21/5/1998 and ultimately on 10/7/1998, office was directed to issue notice to the DVC. ये DVC को notice है ना?
जी
To DVC, and thereafter the matter remained pending for appearance. The learned counsel has submitted that at no point of time the proceeding was set ex parte, nor at any point of time any date was fixed for the purposes of adducing evidence on behalf of the appellant. The learned counsel submits that suddenly on 2011-2002, the learned land acquisition judge recorded that the applicant has not been taking any steps since long, and recorded that the appellant had no intention, had no interest in the case, and ultimately upheld the award given by the District Land Acquisition Dhanbad by exercising power under Section 18 of the Land Acquisition Act and disposed of the matter, directing the office to prepare a decree. The order dated 2011-2002 is copied as
Which is followed by a decree dated 9/12/2009.
Subsequently, the decree was drawn and the first appeal was filed. The learned counsel for the appellant has submitted that the learned court has not followed the procedure, and the matter remained pending for years together, primarily for appearance of the opposite party. And under such circumstances, the impugned judgment and decree be set aside and matter be remanded to the court to enable the parties to lead evidence so that appropriate compensation may be fixed. The learned counsel for the respondent number
2.
Respondent number 2.
In my submission, it may only be recorded that so far as for the purpose of sake of argument, that since 15 to 92, the matter was posted for hearing. Meaning
The learned counsel submits that since the year 1990, since 16 to 1992,
15
to 1992, the matter was posted for hearing,
Okay.
and therefore the appellant ought to have adduced evidence himself.
And further that's since 15/10/2001 till passing of the impugned judgment, they have taken not any step for consecutive 6 dates.
The learned counsel has
15/10/2001
also submitted that from
10/2001
2001
till passing of the
till passing of the impugned judgment, the appellant had also not taken any steps.
that is for a period of more than 1 year.
That is for a period of more than 1 year. However, it is not in dispute that at any point of time the proceeding was not set ex parte, nor there is any service report in connection with the newly added respondent or the in connection with one or the other respondent, right? After nobody appears on behalf of the state. After hearing the learned counsel for the parties and having gone through the order sheet of the learned court, this court finds that admittedly the reference case was instituted, land acquisition reference case number 105 of 90 was instituted on 27/10/1990 and notices were issued on 16/11/1990. The appellant appeared by filing wakalatnama on 17/12/1990 and the government pleader was directed to be informed. However, on large number of dates, the appellant has been taking steps, but no steps were being taken from the side of the respondent state. The fact also remains that subsequently, on the application filed by the appellant, a petition for addition of party of DVC under Order 1 Rule 10 CPC was allowed on 21/5/1998 and the office was directed to issue notice by the order dated 10/7/1998. However, it appears that the court recorded that proper steps were not being taken by the parties. The record does not reveal appearance of the opposite parties before the court, and there is no order setting the proceeding ex parte. Nor there is any order asking the appellant, who was the applicant, to adduce evidence. And ultimately the case was, in the impugned order as quoted above, dated 20/11/2002, has been passed. There is no recording regarding service of notice upon the opposite party. This court finds that the matter was essentially pending for appearance of the respondents. as the records does not reveal service of notice upon the respondents. In such circumstances, the impugned order dated 2011-2002 on the ground that the appellant had not taken any step cannot be sustained in the eyes of law. The matter relates to enhancement of compensation under Land Acquisition Act. एक ना ऊपर पॉइंट फॉर डिटर्मिनेशन तो बनाना ही पड़ेगा।
और यहाँ पर जो ये ऑनरेबल कोर्ट के द्वारा क्या है, मैटर रिलेट्स टू एनहांसमेंट, इस पर अगर वो लाइन जोड़ दिया जाए रिलेट्स टू क्लेम, बिकॉज समटाइम्स ऑन रिमांड the learned judges may be prejudiced by one.
Relates to
their claim
compensation.
Relates to compensation.
Compensation under Land Acquisition Act. A point of determination बना लेंगे, ठीक है ना? The point of determination would be whether the learned court has followed the due procedure while passing the impugned order dated 2011-2002. Accordingly, the impugned judgment and decree is hereby set aside. The parties are directed to appear before the learned जो भी court है,
Land acquisition judge,
Land Acquisition Judge
successor land acquisition judge,
Slash-
Dhanbad.
its successor at Dhanbad. Date रहेगा. Since the counsel for the state is not appearing, let a copy of this judgment be forwarded to the office of Learned Advocate General to ensure that the state also participates in the proceedings before the learned court. Considering the fact that the land acquisition reference case is of the year 1990, the parties are directed to cooperate with for early disposal of it.
If the learned judge is requested to inform or issue notice to the concerned
किस
party,
day? यहीं से हम fix कर दिए date.
सबको जानकारी हो गई।
AG को खबर कर दिए, हो गया जानकारी,
हो गया, हमको भी मालूम।
आपको मालूम हो गया, इनको भी
on
मालूम हो
that
गया.
date we will be
बात
present
खत्म.
there.
अगला,
इतना थोड़ी अब वहाँ से नोटिस करते रहेंगे. इसी
ठीक है।
नोटिस के चक्कर में तो ये कहानी है.
जो 32 साल की थी, फिर यहाँ आए तो यहाँ हो गया जो परिवार का 1984 का लैंड एक्विजिशन आयोग 2025 एक आदमी को मर गया। एक
अब 32 दिन नहीं बीतेगा, ऑर्डर साइन होने में जितना टाइम लगे हम नहीं जानते.
इस वजह से
This case from Substitution list item 1, second April 28 of 1999.
I'll give a date. जजमेंट में डेट रहेगा, अभी करेक्शन में टाइम लगता है, इसमें ज़्यादा टाइम नहीं लगेगा इसको करेक्शन में. Yes, please, who is appearing? You have seen the question of law?
Lordship, I'll start, but I'll also pray that next hearing I may be allowed to conclude on Monday. Very short point involved, but I need to just point out relevant facts in
देखिए
one
आप
page or
सारा
two.
चीज हम लोग देख चुके हैं,
हाँ,
ठीक है. अब आपको सीधे मुद्दे पे आना है, आपको टाइम चाहिए तो टाइम ले लीजिए, क्योंकि सारा जजमेंट हम लोग पढ़ चुके
ठीक
हैं
है,
already.
ठीक है. तो Monday,
Yesterday we have
Monday,
just
Monday
read the entire
हम लंबा कोई ये नहीं कर रहे हैं. Monday, I'll take not more than 20 minutes to half.
तो थोड़ा सा आपका जो रिकॉर्ड पर अवेलेबल है उतना लिखा देते हैं, मेरा पार्ट डिक्टेशन तो हो जाएगा ना. You get it?
ठीक है. My main submission would be whatever finding is there of the trial court with regard to the fact that they had knowledge about the agreement
Okay.
prior to their purchase.
Trial court.
Sale deed. Yes.
Appellate court?
Appellate court reverses on that.
Yes.
That is the reason that this substantial question of law was framed.
But I may just indicate one thing so that Mr. Gupta also prepares on that line. Because not the trial court decreed the suit of specific performance without even formulating a question or issue of readiness and willingness. So I will be arguing that also, that in a suit for specific performance, not the criteria of law is not 16
देखिए ऐसा है
16C.
जो लॉ बना है
हाँ ठीक है वो question of law, but I would be arguing on that. So Mr. Gupta,
why where is the
No,
scope?
because
no,
this
because
would not
if
be
your
open
if your
for-
lordship
Where
decrees
is the
or
scope?
no, now not the scope is that if a trial court decreed a suit, there is an appeal against that finding. The appellate court reverses it on a particular point. But both courts have not framed issue of readiness and willingness.
So
So
he
are,
was
where is your appeal?
But
Where is your cross
I am not
appeal?
aggrieved on that because the appellate court not decides in my favor.
देखिए फर्स्ट एपिलेट कोर्ट का तो कहानी समझ में आएगा
हाँ,
है ना, लेकिन आपका ये सेकंड अपील में ये सब कहानी नहीं
नहीं।
चलेगा। आपके कहने से हम कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ कैसे
but हम
करेंगे?
question of law हम तो बोल रहे हैं not the judgment of the trial court is vitiated for not considering the mandatory
बोलने
requirement
बिना
of law.
क्वेश्चन ऑफ लॉ बनाए तो हम उसको कैसे
So,
सुनेंगे?
but your lordship will see, my lords. in
I
this.
will not see. I will only confine myself to the substantial question of law.
Then-
That's it.
Then not definitely not that issue because your lordship will then if allows the appeal.
I'll answer to this.
ये
your
ना
lordships allows the appeal.
open-ended type से
Then
नहीं
if your lordships allows the appeal, not what will be the consequences?
We will
How
see.
plaintiff without being
Simple
any
one
issue.
line answer I'll give, that this particular finding, if it was against him, if he did not raise it before the trial court, that with regard to my readiness in willing, then he was required to raise it before the first appellate court. Even by
There
the
is no finding.
He
There
is
is no
not-
finding.
so
There is no
this is-
issue on that. That is my point. There is no finding. There is no issue by any of the courts below.
Exactly. ऐसे नहीं हम फ्रेम कर सकते हैं कोई भी issue.
Because this arises out of the pleadings note there, and this is the mandate of law. In a landlord-tenant relationship, the lordship will see not whether there is relationship and then only proceed for eviction. In this kind of a suit, if there is no readiness and willingness on part of the plaintiff, which has been pleaded and proved, your lordship is aware of that judgment. Lord, I have got your lordship's judgment also and a recent Supreme Court judgment also on that. How can the trial court decree the suit?
ये
So he
क्वेश्चन तो
was
आपको
the
ट्रायल
guy-
कोर्ट से पूछना चाहिए था.
ये अपील
Therefore,
में एक बार रेज करेंगे ना, अपील में he
You
was
see,
the
I'll
appellant.
tell you one
Yes.
thing. I will confine myself only to the substantial question. I will not travel. आपका सब लिखा देंगे, लेकिन I will not answer it. I will not answer it. I'm making it very clear. I will answer whatever has been framed. I will give you.
Yes.
रोज यही जजमेंट आ रहा है सुप्रीम कोर्ट का. You cannot travel beyond whatever has been framed. Rather, defendant number 1
Yes.
did not even depose before the court. है ना?
Not the vendor did not file his written statement. The vendor did not file his written statement.
Yes.
And in another written statement, another suit, she has admitted that they had the knowledge about the entire agreement. And his own evidence has come that he has not even made an inquiry with regard to any agreement. Therefore, your lordship, in terms of Transfer of Property Act, where it has been defined that a person would have be said to have knowledge about a particular fact if he abstains from inquiry. And in his evidence, it has come that he did not even make any inquiry whatsoever prior to
किससे
purchase.
inquiry करना?
But I have inquired from the vendor's son, that is there in the evidence.
All these things, your lordship,
Ah.
I'll answer.
Just a minute. आप लोग आ गए हैं तो कोई केस इतना आसानी से खुद छोड़. What was the consideration amount?
But 40,000 was the consideration amount. 1,000 was paid. What is alleged in the agreement. And the vendor was in possession, and pursuant to the sale deed, I am in possession since last 45 years.
And they have themselves admitted that they have not paid the entire consideration amount with regard to the sale. This has also come.
We have paid after the sale deed, that your lordship is a.
So all
Yes,
these
so
things
far-
have to be seen. It is his own admission that he has not paid the entire
the time of sale date, but after that we have paid the entire amount and possession have been delivered in 81. That is the finding of the appellant.
Yes, it can be used. You are the plaintiff.
No, I'm the
Defendant number 2 and 3.
Yes.
You are the
I
plaintiff.
am the original plaintiff. I had filed a suit for specific purpose that was decreed, and they had preferred first appeal.
Just defendant number did not file any written statement.
Defendant number 1.
No, one day.
So readiness and willingness will be qua defendant number 1. Right?
Yes.
So sons and daughters were made party. They also did not file any written statement. Correct?
Yes.
And it was only contested by defendant number 2 and 3.
2 and 3. What the subject?
Then there is an averment of readiness and willingness.
Yes, paragraph 7 of the plaint.
It is there.
It is
It is
there.
recorded in the entry
Yes, yes.
judgment also. So this remained undisputed.
But
Let me just say,
yes.
this remained undisputed because you could not have disputed it. It was only defendant number 1 who could have disputed. Right? So ultimately,
Yes.
what happened was that no such issue was framed, nor any such pleading was taken from your end. Right? You could have also taken a plea like one
Yes.
that he never had the capacity to pay. Right? That was all still open to you.
But
Even if
I
he
will just
showed
indicate one thing. Notes, we have also filed a cross objection, and that notes by
cross objection before whom?
before the High Court notes
Here.
here, and that note was dismissed for non-prosecution due to our latches on 2/8/22. There is a CMP for restoration of this.
So we can't do anything about
Not, I must indicate that because we have also filed a cross objection against
it.
this
CMP
judgment.
number?
Yes, but CMP number is 775 of 2022. Cross objection is 6 of 2006.
May I point out one thing? It was absolute. Now
CO
they
number?
could have.
But there
Is
is CO
6
number?
of 2006 months.
ये CMP का status देखिए 775 of 2002. और यहाँ पे हम यही इशू को आंसर करेंगे. आपका वो क्रॉस ऑब्जेक्शन अगर रेस्टोर होगा तो देखेंगे क्या होगा. That is a separate issue.
Yes, that is a separate issue.
Distinct issue altogether.
But-
If you have raised the point regarding readiness and willingness.
But in this CMP notices have been issued, and perhaps they have not appeared. This is the order.
कौन से कोर्ट से issue?
Court number 9.
We can just observe that so far as this CO is concerned, if it is restored, since it's a cross objection or it's a cross objection,
No, it is cross objection. 4122.
can it be decided independent of this? If restored? Then
But
can
Well,
it be
it
decided
arises-
independent of this?
no, it arises out of the same judgment. So, because only Friday is the date. I will mention it before court number 9. See,
Mention की बात नहीं कर रहे, हम ऐसे पूछ
And
रहे हैं.
they-
Can
no,
this appeal be decided independent of your cross objection?
but I don't think it should be because
I'm
ठीक
not
से मत
aware what
बताइए
is
भाई,
there.
लॉ से बताइए. आप सोच, आपका सोच लॉ में ट्रांसलेट करने में हमको जजमेंट करना पड़ता है.
सोच का बात नहीं ना. But if I am also aggrieved by certain findings of the appellate, first appellate court, I have also
Which
filed.
finding are you agreed with?
But that so I'm.
इस ग्राउंड पे हम इस केस को एडजर्न नहीं करते.
हम एडजोर्नमेंट नहीं मांगते.
तो
हम
बस
तो बोल रहे कि हाँ, बट हम खाली इतना रिक्वेस्ट करें कि अगर इनको क्योंकि नोटिस है इस बात का या इनको अभी पता चल गया है क्रॉस ऑब्जेक्शन इसमें सीएमपी में हुआ है एंड दे वर अपीयरिंग इन द क्रॉस ऑब्जेक्शन इनिशियली बिकॉज दैट वाज टैग्ड अलोंग विद द सेकंड अपील. द लॉर्डशिप में सीम नोट्स द ऑर्डर, सो दे आर अवेयर ऑफ दिस फैक्ट दैट देयर इज अ क्रॉस ऑब्जेक्शन.
that was also admitted.
Yes, that was admitted. Not your lordship may see the order by which it has been dismissed for default. The appellant not here took 20 weeks time, and not since we were not appearing or we could not appear, not my cross objection was dismissed. So by the same order, it has been they were granted 20 weeks time, and my cross objection was dismissed for non-prosecution.
We are not late for 20 weeks. The court granted 20. It says that heard the learned counsel for the appellant, learned counsel appellant prays for time, prayer for chance, time is allowed as last chance,
But-
this appeal after 20. So
This is
I have
not
we have
something
not.
here in court. Now, what the practical aspect, we know that whatever time we pray, the court grants. So it
Cross
can't.
objection has been dismissed for default. वो चल रहा है आपका restoration में. That cannot be a ground for adjourning this case. I will confine the findings only to the extent it relates to it.
Not my only issue here is not that in a suit for specific performance, your lordship will
हम
see.
सुन लिया आपका बात.
So, Lord, if your lordship confines your lordship to only the question of law formulated here,
That's it.
and then Lord answers it, will your lordship not decrease the suit? Because in a suit for specific performance, without the issue of readiness and willingness being taken into consideration, will your lordship decree a suit? But let me assume for a moment, Lord, if the plaintiff comes in a case of specific performance, there is no written statement, nobody appears, no one contests. Then also there is no written statement, there is no denial of that readiness, willingness pleading. Then also your lordship has held that it was the requirement for the plaintiff to plead
Okay,
and prove.
We will see your plea also.
Yes,
आपका सबमिशन हम रिकॉर्ड जरूर करेंगे, लेकिन बाकी हमको जो करना होगा वही करेंगे.
हाँ.
Because the consequence of
yes.
answering this substantial question of law has also to be taken to a logical end.
Yes. Therefore I say
Who decreed the suit?
the trial court.
Trial. And if they file first appeal, if they do not take this ground before the first appellate court, can the first
You were
appellate
the
court?
first appellate.
Yes, but the suit was decreed, we filed an appeal, and the appeal was allowed.
So did you take this plea before the first appellate court that there is no pleading and proof of
But
readiness
that
and
memo of
willingness?
appeal I don't have because certified copy निकाले वहाँ से
Memo of
check
appeal
कर.
तो अब इंक्लूड जजमेंट में ही मिलेगा ना, क्या क्या ग्राउंड लिया है.
नहीं वैसा मेरे जजमेंट में है नहीं कि क्या क्या पॉइंट्स लिया हुआ है.
ठीक है, सुनते हैं, चलिए अपना हियरिंग शुरू करें. देखिए तो Second appeal number 78 of 1999 within bracket R. The learned counsel for the parties are present. This appeal has been admitted for final hearing by the order dated 21/11/2000 on the following substantial question of law. Quote, whether the Court of Appeal below erred in law in holding that defendant number 2 and 3 had neither actual nor constructive notice of the agreement for sale in favor of the plaintiff. The suit was filed for a decree of specific performance of contract between the plaintiff and the original defendant number 1, Mohammad Saliman, dated 5/8/1979, within bracket Exhibit 5.
Exhibit 5, yes.
Exhibit 5. And also for the direction upon the other defendants to join in the conveyance a prayer for permanent injunction was also made. The learned trial court had decreed the suit upon appeal filed by the defendant number 1 and 2. The learned first appellate court reversed the judgment and consequently the plaintiff is the appellant before this court. It further appears that against the trial court judgment dated कौन सा तारीख है ट्रायल कोर्ट का जजमेंट?
क्या पैराग्राफ का?
ट्रायल कोर्ट का जजमेंट
This is your 11th March 1988.
dated 11th March 1998.
1988.
1988, passed in title suit number 43 of 1981. First appeal number, the title appeal number 27 of 1988 was filed, which was disposed of by judgment dated 6th March 1991 by way of remand. The learned first appellate court also framed the point for determination in paragraph 7 while remanding the matter, which is quoted as under 7. The points for consideration are Roman 1. Was the agreement dated 5/8/1979 genuine and valid? Roman 2. Had the defendants purchased the suit property on 25/1/80 with due knowledge of the agreement to sale dated 5/8/79, and Roman 3. Was the suit barred under the provisions of Order 2, Rule 2 of CPC and under other provisions of law. While remanding the matter, the following observations were also made in paragraph 8. इसको भी quote करना 8 and 9. The French judgment was passed by the learned First Appellate Court on 31st of July 1999. And the point and following points of determination were framed keeping in view the order of remand passed by the learned First Appellate Court dated 6 March 1991 in title appeal number 27 of 1988. The points for determination by the learned First Appellate Court are as under. The learned counsel for the respondents at the threshold has submitted that neither the trial court nor the First Appellate Court has framed any issue on the point of readiness and willingness on the part of the plaintiff to perform his part of the contract relating to Exhibit 5. He has also submitted that though no substantial question of law has been framed on this point, but if the substantial question of law is answered in favor of the appellant, then under such circumstances, the aforesaid point is also required to be taken into consideration. And if the appeal is decided against the appellant on the substantial question of law, then he has nothing to say. Correct? Anna? The learned counsel for the appellant, in response to the submission, has submitted that law is well settled that at the second appellate stage, the court has to confine itself to the substantial question of law so framed. The learned counsel has also submitted that the respondent is otherwise also stopped from raising such a plea in view of the fact that the fresh First Appellate Court judgment has been passed after the order of remand, wherein specific issues were also indicated which were required to be decided by the learned First Appellate Court. He has also submitted that the first appeal was filed by the respondent before the learned First Appellate Court, and at any point of time, the respondent never raised any objection with regard to framing of issue by the learned trial court on the point of readiness and willingness to perform regarding performance of the part of the contract by the plaintiff, and even before the first appellate court, no such plea was raised.
Yes, and his submissions are mentioned in para 8 of the impugned judgment where no such ground
The
was.
learned counsel has submitted that the submissions are specifically recorded in paragraph 8
Yes.
of the impugned judgment where no such ground has been raised.
Over and above that, in para 7, your lordship observed that we have made the statement of readiness and willingness. In para,
I just record it.
yes,
The learned counsel has submitted that in paragraph 7 of the plaint, a plea was raised that the plaintiff was ready and willing to perform his part of the contract. But the defendant number 1, with whom the agreement was entered into, that is Exhibit 5, never appeared before the court nor filed any written statement, and at any point of time he did not participate in the proceedings.
and there is one written statement by the guardian of the defendant number 1 who they had filed.
Okay, guardian.
Yes. Yes. Written statement on behalf of the minor defendant number 1B to 1D. GAL, guardian had written probably. Nothing has been mentioned.
The learned counsel has submitted that the guardian upon death of defendant number 1, she
So
she was substituted and written statement was filed on behalf of the legal heirs, minor legal heirs, through the guardian.
Yes.
Taken as a-
And it was said that up till now, neither minor defendant nor their guardian up to jail, as such, he is not in a position to accept or deny the statement made in the plea. That is all.
And
This is
no
the
objection with regard to readiness and willingness was taken.
second is even in their written statement by defendant number 2 and 3, in para 7 of their written statement, they only say that these defendants have no knowledge of any notice dated so and so as alleged in para 7 and 8 of the plaint. And in para 7 of my plaint, I have mentioned.
The learned counsel has also submitted that so far as the written statement filed by defendant number 2 and 3 is concerned, they also did not dispute this statement made by the plaintiff that they were really, ready and willing to perform their part of the contract. The learned counsel has submitted that since the readiness and willingness to perform the part of the contract on the part of the plaintiff was not in dispute, neither any issue was framed by the learned trial court nor any such issue was framed by the learned first appellate court, and the substantial question of law framed by this court is only required to be answered. हो गया आपका इस पॉइंट पर कहानी, ठीक है, और बताइए क्या बोलना है, मेरिट पे कब करेंगे बताइए?
Monday.
The learned counsel for the appellant submits that he has to go through the records of this case and accordingly he prays that the matter be posted on Monday. आपको क्या बोलना है? The learned counsel for the respondent has no objection to the prayer made. Monday के लिए कोई हम लोग टाइम फिक्स करेंगे किसी केस में? Pose this case for final disposal on Monday. No, under the same heading on Monday to be taken up as the first case. 10:30.
2:15.
10:30.
10.
2:15 में खाली first appeal करते हैं.
अच्छा ठीक. Good.
10:30 बजे.
ठीक.
बड़ा वाला फोल्डर लेकर यह सब हट के चला जाएगा साइड से.
Item 2 from date is 2nd April 5/08 of 2004.
So there is IA for substitution. Number 2.05.08.2024. There is some discrepancy in this IA.
What discrepancy?
I may be permitted to withdraw this IA for filing of fresh IA.
क्या है इसमें डिस्क्रिपेंसी हो गया? एफिडेविट में आईए फाइल किया सब्स्टिट्यूशन का, इसमें क्या डिस्क्रिपेंसी हो गया?
Some wrong facts are written in para 2.
They are not appellants before this court. Appellant number 1 and 6.
Appellant. Lordship, the Santosh Pandey are the respondent to appellant number 2, Lordship, but it has been wrongly mentioned appellant number 6. This is appellant number 6. Santosh Pandey is the appellant number 2.
Who has expired?
Appellant number 7.
इसको विड्रॉ आपको क्यों करना है? अब अपीलेंट नंबर 6 से क्या लेना देना है जब अपीलेंट नंबर 7 का डेथ हुआ है?
ठीक है तो उसको
Just tell me.
but it has been wrongly mentioned this is appellant number 6.
It should be deceased appellant number 7 और नाम भी गलत लिखा है.
नाम भी गलत लिखा है जी.
ठीक. What who has expired is only appellant number 7.
7 Lord.
Appellant number 6 is surviving.
Yes, yes.
इतना मेरे को दिक्कत नहीं है. We'll just record. और वकालतनामा है. देखिए आईए नंबर 2245 of 2024 in essay number 588 of 2004. Counsel for the appellant has submitted that this petition has been filed for substitution of deceased appellant number 7, namely Nareshwar Pandey, who died during the pendency of this appeal on 30/9/2023, leaving behind his legal heirs and successors whose details have been mentioned in paragraph 1 of the interrogatory application. The learned counsel submits that due to inadvertence, it has been mentioned in paragraph 2 that the appellant number 6, namely Santosh Pandey, has expired. But who has expired is actually appellant number 7. He has submitted that a prayer has also been made for substitution of appellant number 7 only. Respondent कौन है? This petition for substitution with the prayer for condonation of delay has been filed on 23/2/2024. However, no counter affidavit as such has been filed to this interrogatory application. Considering the averments made in the interrogatory application, the prayer for substitution is allowed. The counsel for the appellant is directed to carry out the necessary amendments in the cause title
In course of the
by deleting the name of appellant number 7 and substituting the name of his legal heirs and successors whose details have been mentioned in paragraph 1 of the interrogatory application. The needful be done during the course of the day. आगे बताइए क्या? अभी कहानी का खत्म है?
next
नहीं कहानी सुनाइए हमको स्टोरी.
में स्केल पढ़े
पढ़े तो नहीं है लेकिन सब्सटेंशियल क्वेश्चन ऑफ लॉ बताइए क्या?
judgment of the person.
ये ऑर्डर 41 रूल है, इसका थोड़ी चल रहा है 11 का हियरिंग.
Sir, ladies,
क्या?
I am appearing for respondent number 10, ladies. Respondent number 10 has died. We have to file the substitution petition.
Respondent number 10 आपको खबर मिला है?
Yes, ladies.
किन से मिला है?
उनके family members.
उनके फैमिली मेंबर्स से। तो लीगल हियर्स एंड सक्सेसर्स का नाम दिए हैं?
Yes, ladies, we have to file substitution.
आप उनका डिटेल्स इनको दे दीजिए ना, सब्स्टिट्यूशन
तुरंत
ये फाइल
फाइल हम ही फाइल करेंगे, आपको नहीं करना।
Will provide the details.
कितना दिन में? 2 दिन में?
Yes. Within a week, within this week.
प्रॉपर्ली मेल में चाहे व्हाट्सएप में लेकर उसका प्रिंट निकाल के इनको हैंड ओवर करिए, इससे कोई कल को डिस्प्यूट नहीं करे। ठीक है?
अच्छा, ऑर्डर 22 रूल 10 में पिटीशन फाइल कर सकते हैं।
ठीक है, फाइल कर दीजिए ऑर्डर 22 रूल 10
रूल 10।
इस बहाने लिटिगेंट आएगा तो सही, उनको बोल दीजिएगा टाइम नहीं हो, उनसे वकालतनामा भी ले लेंगे, जो भी लीगली एसेंट सक्सेसर्स हैं उनका वकालतनामा साइन करा के आएंगे, तभी ये केस डिसाइड होगा ना। ठीक है? क्या नाम है आपका?
उत्पल खान।
Second appeal number further लिखिए। The learned counsel for the respondent has submitted that he has been informed by the family members of respondent number 10 that he has expired.
Yes.
The learned counsel submits that a petition under order 22 rule 10A will be filed before this court, giving the details of legal heirs and successors of deceased respondent number 10, and if possible he shall also obtain the वकालतनामा while filing the petition. ठीक है, साथ में लगा दीजिए।
Yes.
At the request of the council, post this case on next Wednesday. ठीक है? देवघर अंडर द सेम हेडिंग, इस किसी का भी हेडिंग चेंज नहीं करना है, सब पुराना वाला केस का लिस्ट पर चलता है।
For hearing item 3, second appeal 170 of 2002.
बताइए,
Where's IE substitution? Sole applied.
वकालतनामा है?
हाँ, वकालतनामा है।
लिखिए।
Within time.
Any objection? IA number 10036 of 2025 in essay number 170 of 2002. The learned counsel for the appellant has submitted that interlocutory application has been filed for substitution of death of sole appellant who expired on 7/5/2025. The names of legal heirs and successors of the sole appellant has been mentioned in paragraph 4 of the interlocutory application, and their wakalatnama has also been placed on record along with the death certificate. The learned counsel for the respondents has no serious objection so far as prayer for substitution is concerned. Considering the amendments made and the submissions, the IA number 10036 of 25 seeking substitution of sole appellant is hereby allowed. The counsel for the appellant is directed to delete the name of the appellant in the cause title and insert the name of the legal heirs and successors in reading during the course of the आगे बताइए क्या? अरे खत्म नहीं हुआ कहानी, अभी स्टोरी बताइए। Second appeal.
This sole respondent has also passed away in mediation, so we bring on recorded affidavit.
Sole respondent. When did he die?
Mediation will just go to the mediation. Both the courts have decreed in our favor on the mediation, but yet neither the arrears have been paid, neither have they evicted the place.
Three.
Must be who told you that he has died? Yes, madam, who has informed you that he has died?
London Council, Your Worship, London Council.
Give his name. Give his name. Who has informed you?
LK Lal. So,
Mr. Ekila.
I'll just confirm, Your Worship, from that, but because here the name of the lawyer is written as Mr. LK, but I think it's from the opposite side, Your Worship. It's not that. But I'll just confirm.
Madam, this is very
It's
important.
Ah,
Because
yes,
we will not
only that.
record death without proper information. Nor we will assume death.
Yes, sir. We are ready with the bill. We are ready with the bill. We are ready with the bill.
There is stay of further proceeding before trial court. Execution has is
Yes,
stayed.
Your Worship, as per order dated 11th of February 2004, I think. Stay.
Twelve nine 2003. Stay.
You have any instructions? Are you still over the property?
I'm in position.
Who has expired, madam?
Your Worship, I'll just confirm it. So far, just now, they are respondent
Sole
Supreme,
respondent.
sole respondent Supreme.
What happened to the appeal under BBC Act? This one. Appeal number 7 of 1993.
In fact, first there was an order was given in the interim order that 100 rupees per month has to be paid, my lords. Against that we came in a writ petition, and that till civil review, they had filed a civil review against that, and that order has been confirmed. Order of the High Court stating that 800 per month has to be paid. However, my ladyship, this for this DC appeal, as that was pending, that was kept pending only because they
That was on rent fixation.
Yes, my ladyship. First, we had filed an suit for rent fixation in 1991, and the rent was fixed at rupees 1663. Against that, they went in appeal before the for the HRC appeal, whereby an interim order was given of 100 rupees per month.
Because there is a direction to dispose of that.
Yes, my ladyship. So as the matter reached High Court, and we had filed a writ against that interim order of 100. So then the High Court had ordered for payment of 800 rupees per month, and later that order was in review, and the opposite counsel, they had filed review, and review was also dismissed. So that order of 800 remained. This DC appeal, 3 months, 2 months time was given to dispose it of, my
So
ladyship.
where are those orders? What is the civil review? All these story will come up on the next date.
My ladyship, all of that is there in the impure order itself, my ladyship.
No. There is an interim order passed by this court on 4/3/2004 asking the DC to dispose of the appeal.
Yes, my ladyship, because that was an
Then
interim.
how is it there in the impugned order?
This is a different one, my ladyship. First, for rent fixation, one we had filed in 91. Against that, they had filed appeal. That is a different one.
That is appeal number 7 of 1993.
Yes, my ladyship.
Yes.
But this is 6 of 94.
There are two matters, Your Worship. That appeal was different, that is against the land fixation. That was,
But there is an order dated 4/3/24 directing the deputy commissioner to dispose of the appeal.
Yes, my lordship.
What
The
happened to
other
that
appeal
appeal?
for rent fixation?
That's right. What happened to that appeal?
I think that appeal was dismissed. But
I will see this.
कुछ नहीं, आप खाली एक टाइम लेने के लिए खाली इंस्ट्रक्शन
बस कर
देन
देंगे।
प्लीज 2002 का मैटर जो है ना, आप बस ये सब
नहीं, हम तो
कहानियां
कर ही रहे हैं।
क्या
टाइम
कर
मांगते
रहे
भी नहीं हैं।
क्या कर
हम तो
रहे
टाइम
हैं?
मांगते भी नहीं, हर केस
वो
में।
मर गए, वो जी गए, इनको यही नहीं पता कि कौन कब मर गया।
उसको छोड़ दिया
हो
जाए।
सकता है प्रोसीडिंग अबेट हो गया हो, who knows about it.
सही।
You have to give the information who is giving you the information.
yes.
Because if it is found that this information is not correct,
Then
we are going to take very serious steps.
But we are the
We
sufferer.
bring the death certificate as well.
We are the,
क्या
along with it. If she has died with
See, RIT में कौन सा ऑर्डर हुआ?
Next.
HRC केस का RIT कौन सा था? What was the RIT number?
My lordship, if we just see this title eviction main suit, my lordship, which is 6 of 94, which we had filed.
Madam, please appreciate.
Yes, my lordship.
There is you have the copy of order dated 4/3/2004 or not? You read it. There is a direction to the deputy commissioner to dispose of the appeal. So therefore, the disposal order will not reflect in the impugned judgment.
Yes, ma'am.
Correct?
Yes.
So I just want to know which is that writ petition in which the final order of the deputy commissioner was challenged.
Not final order, my lordship. Interim order of deputy commissioner.
That is still
was
pending.
challenged. No, my lordship.
This what happened in the final judgment in the deputy by the deputy commissioner.
They will tell you. They have preferred that.
वो अपील पेंडिंग है अभी तक.
I will seek instruction, Lord, sir. I will seek instruction, Lord, sir.
This appeal was
अरे भाई
preferred by-
कौन से रिट में क्या चैलेंज हुआ था? इंटरिम ऑर्डर was challenged in the writ
Of
petition.
DC. Yes, my lordship.
Where is what is that writ petition number?
That is.
Give me the number. इतना रिव्यू का कहानी सुना रहे हैं, अभी आपको पता ही नहीं रिट का नंबर.
That is CWJC 34 of 1994.
34 of 94.
Yes, my lordship.
No.
Yes, my lordship. My lordship, that is a different case. First, we had filed for rent fixation.
You have the order dated 4/3/2004.
Yes, my lordship.
Please read it. Read the second part. Read the second part of this order. Second paragraph. Read it, please.
My lordship, we have what is written in our listing, my lordship, that DC is directed to dispose of the appeal within 2 months and report to the court.
So,
My lordship, this same deputy commissioner's interim order was challenged before this.
we are not bothered about interim order.
Yes, my lordship, that's true, but this pertains to rent fixation.
We were not doing that. The appeal was preferred by them,
Yes.
not by us.
This is for eviction suit and that is for rent fixation, my lordship.
Land fixation, they have.
Eviction suit has been allowed and that was for rent fixation, my lordship. Against the rent fixation order, they had filed appeal, that is being directed to be disposed of, my lordship. And we have come against the interim order and against that interim order, even review has been
Not
filed.
bothered about it. I just want to know whether the proceeding before the deputy
That they will
commissioner has
have to
commenced
tell,
or
my
not.
lordship. But the learned High Court itself has said to dispose it within 2 months, my lordship.
You are for the landlord.
Yes, my lordship.
So you are not bothered. You don't care.
That rent fixation case, that is already final, my lordship, because eviction has been,
Review was
Given
dismissed. I
to
have
me.
the copy, Lord.
eviction has been
Review was
decreed, my
dismissed.
lordship.
Eviction has been decreed
Yes, my lordship.
on the basis of the rent fixation order.
No, my
Two
lordship.
suits.
No, it's two separate proceedings, my lordship.
You see, you read the substantial question of law.
My lordship, that has been framed by them, my lordship.
The suit was decreed of eviction after the disposal of the appeal. Madam, please, I just can't help.
That issue has been framed mediation, but the appeal has not been disclosed, which is seen from this order.
दिखाइए उनको दिखाइए. Next case call करिए. You go through the record and just let me know. दो judgment, दो order दिखाइए. Substantial question of law, and then ultimately there was a direction by the court that the issue should decide the appeal. Next case call करिए. Substitution आपका हो गया?
जी.
We'll record that she says that somebody has also expired.
Item 4, second appeal 391 of 2003.
Suit for specific purposes of contract. The suit was defeated.
Who are you? You are the applicant. You are the plaintiff.
Plaintiff.
Concurrent finding or reversal?
Reversal. Suit was decreed in my favor, which was reversed by the first appellate court. So the substantial question whether the first appellate court has favored a legal approach.
Who is for the respondent? Are you appearing?
Yes.
Order dated 13/8/2004 has been admitted on the substantial question whether the lower appellate court has adopted a wrong legal approach in setting aside and reversing the judgment. Because fact यहाँ पर कहानी बहुत छोटा है कि सोनिया कुमारी has acquired 1.5 कट्ठा of land by his father-in-law through registered sale. Sonia Kumari died leaving behind 3 sons. 3 sons, Hira Singh, Dasrath Singh and Anand Singh उर्फ जट्टू सिंह. तो तीनों को मिला आधा आधा कट्ठा. ये आधा कट्ठा हीरा सिंह और दशरथ सिंह वो दोनों हमको बेच दिए और ये अनंत सिंह उर्फ जट्टू सिंह का ही डिस्प्यूट रह गया. वो हमारे साथ एग्रीमेंट किए और एग्रीमेंट करने के बाद वो दूसरे आदमी को बेचने का जब इंटेंशन दिखाए तो हम अप्रोच किया, नहीं माने तो फिर हम सूट फाइल किए. ड्यूरिंग पेंडेंसी ऑफ द सूट द जट्टू सिंह एंड हिज सन sold the land to private respondent number, dependent second party and third party. So subsequently the suit was amended and both the sale deed was also challenged, which was decreed in favor of the plaintiff because of the fact that the doctrine of least penalties is applied in this case. However,
those sale deeds were set aside.
Yes, both the sale deeds were set aside. And direction was given to perform the specific contract, and which was reversed by the appellate court by giving
What is the point of determination by the learned first appellate court?
देखा जाए पारा 8 देखा जाए वेरी इंटरेस्टिंगली पारा 8 में कहते हैं after going through the pleading of the parties, I find that the only issue involved in this case is whether the relief of a specific performance of contract could be granted to the plaintiff in the fact and circumstances. So no proper point of determination in terms of order 41/31 has been framed by the first appellate court. And the reasoning, if your lordship will see,
ये आधा मत पढ़िए, पूरा पढ़िए. After going through the pleadings, only issue पढ़िए ना.
After going through the pleadings of the parties, I find that the only issue involved in this case is whether the relief of a specific performance of contract could be granted to the plaintiff in the facts and circumstances of this case. It appears that the court below has framed many unnecessary issues. Although he has given issues and discussed with respect to the admitted facts which were not at all necessary for deciding the suit. Issue number 4 and 5 are the only important issue to be decided in this case. So they if this is to be treated as a point of determination,
They have taken only issue number 4 and 5.
yes.
क्या finding record करते हैं?
फाइंडिंग रिकॉर्ड में करते हैं कि since the land has been sold, so no specific performance can be granted, which is completely illogical and against the judgment of the honorable Supreme Court also. भारत 11 में लास्ट में देखा जाए
तो consequence क्या होगा? आपका अगर point of law आपके favor में decide करते तो क्या होगा?
तो हमारे फेवर में सूट का जो डिग्री रह जाएगा तो हमारे फेवर में जो रजिस्ट्री करेंगे वो
भाई the first appellate court has misdirected itself in deciding and has not considered the relevant issues which were to be considered. Then under such circumstances आपको automatic यहाँ से sustain हो जाएगा ट्रायल कोर्ट का जजमेंट कि हम लोग appellate court को बोलेंगे कि इस इशू को आप डिसाइड करें. बोलना पड़ेगा ना.
नहीं either your lordship में
भाई सेकेंड अपील में कैसे करेंगे? फर्स्ट अपील में तो हम लोग बहुत चीज कर सकते हैं, सेकेंड अपील में कैसे करेंगे? सेकेंड अपील में तो वी कैन ओनली से दैट दिस द रेलेवेंट इश्यूज हैव नॉट बीन टेकन इनटू कंसीडरेशन. रेडीनेस एंड विलिंगनेस, वेदर द एग्रीमेंट पर बोल दिया है कि इट इज एग्जिस्टिंग.
That agreement was found to be genuine by the trial court
and also by the appellate court.
Appellate court says no, not the plaintiff failed to prove the genuineness of it. Although the defendant are claiming that it is not genuine, so burden of proof lies upon the defendant, who has not even the judge to see not appeared, although he was alive at the relevant point of time, but not appeared before the court to depose that whether his signature is there or not, and no other document was or evidence was produced by the defendant.
He filed written statement.
Written statement they have filed, and but signature of Jattu Singh was not there in this.
Not disputed.
Not there in the written statement.
Did he dispute about the execution of the agreement?
Not at all.
Did he dispute it or he did not dispute it in the written statement?
Some defendant disputed. Some
Jattu Singh disputed or
not disputed. हम तो ये कहेंगे इसलिए कि वो अपीयर नहीं किया, डिस्प्यूट किया नहीं, उनके लड़के लोग कर रहे हैं.
भी नहीं अगर डिस्प्यूट किए तब तो
उनके लड़के लोग किए. और एक लड़का गौतम सिंह, he has deposed before the London trial court that yes, it is the signature of my father. So defendant witness is also in my favor.
अभी लंच टाइम हो गया. सेकेंड हाफ में एक हम लोग का हियरिंग चल रहा है फर्स्ट अपील का.
जब तो फिक्स देख रहे हैं लिस्ट पे
कल सुनेंगे.
सप्लीमेंट सब
कल सुनेंगे.
कल ठीक.
Second appeal number 391 of 2003. The counsel for the appellant has commenced the hearing of this case. Post this case for further hearing tomorrow.
परसों रख दिया जाएगा तो हम नोट्स ऑफ आर्गुमेंट बना के लेते हैं.
कोई जरूरत नहीं है, हम जजमेंट पढ़ के देते हैं.
Yes,
स्पेसिफिक परफॉर्मेंस का कोई नोट्स का जरूरत नहीं है.
जरूरत नहीं है, लेकिन बहुत the manner the appellate court has dealt with the matter, that is only to concern.
We'll see that. Yes.
Yes, Your Lordship. In this case, the substantial question of law is being framed by the appellant and the concerned court, Your Lordship, that against the order passed by the HRC, which the appeal is being pending. So can he be considered to the defaulter still the appeal? So they had to tell whether the appeal is pending or not. Because after that notice will issue, Your Lordship. So appeal. And even if the appeal is disposed, so what is the order in that appeal? As per that.
लिखिए सेकेंड अपील नंबर 170 of 2002. वो एक सब्स्टिट्यूशन किए थे. डेथ भी हो गया किसी का ना, पता नहीं.
Sole respondent का death हुआ, Your Lordship.
The learned counsel for the respondent has submitted that he has been informed that the sole respondent has expired. Office is directed to call for a report from the Court of Learned Sub-Judge, First Court, Dhanbad, or his successor court as to whether in the execution case number 22 of 1997, the plaintiff has been substituted. वहाँ से पता लग जाएगा. The order dated 4/3/2024 reveals that a direction was issued to the Deputy Commissioner Dhanbad, the appellate authority under Bihar Building (Lease, Rent and Eviction (Control Act) to hear and finally dispose of the appeal number 7 of 1993 within a period of 2 months from the date of receipt of the copy of the order and report the factum of the disposal to this court along with a copy of the order passed by him. But no such communication has been received so far, as it appears from the available records. Office is also directed to forward a copy of the order dated 4/3/2004 along with this order to the Deputy Commissioner Dhanbad, asking the state authority to forward a copy of the final order passed in appeal number 7 of 1993. Let the needful be done through the officer in charge. Let the communication of these orders be done through the officer in charge of the concerned police station. ठीक है? आप लोग भी
They'll
पता
also,
करें.
they'll also
Yes,
see.
I will also
बाकी
see.
parties are also directed to seek instructions. Post this case on
20th of August.
1st of September under the same.
It's so lucky it has right notes. He
वो तो
provide the,
substitution हो गया आपका.
he provide the names and legally set up the deceased sole appellant's lots.
Sole appellant क्या?
Sorry, respondent, sorry.
If she has died, I'll
Respondent.
provide the
The
Yes,
learned counsel
respondent.
for the sole respondent has
If
also
she-
submitted
Yes.
that she shall provide the details of the legal heirs and successors of the sole respondent to the learned counsel for the appellant within a period of 1 week.